and a very good morning to our esteemed dignitaries, participants, faculty, and students. A warm and gracious morning to each one of you. I am Rishita Sethi.
And I am Tanvi Agrawal.
Final year students at NLIU Bhopal, and it is with immense pleasure that we extend a heartfelt welcome to all of you to the first edition of NLIU SBA Law Conclave. Today marks the beginning of a truly enriching journey, one that brings together minds committed to thoughtful dialogue and pursuit of legal excellence. As we gather to celebrate 75 years of the Supreme Court of India, we not only honor its remarkable legacy, but also engage in conversations that will shape the future of legal landscape. This two-day conclave is more than just an event. It's a celebration of ideas, of institutional strength, and of transformative legal thought. As we launch the very first edition of NLIU SBA Law Conclave, we come together not just as attendees, but as active contributors to the shared vision of academic growth and legal innovation.
With each session and interaction, we embrace an opportunity to learn, grow, and engage with the evolving dimensions of law and justice. Once again, a very warm welcome to each one of you. Let us commence this conclave with enthusiasm. It is now our honor to introduce the distinguished dignitaries who have graced this occasion with their presence.
Firstly, we have with us Honorable Justice Shri Pankaj Mittal, Judge, Supreme Court of India, as the chief guest for the inaugural ceremony. Justice Mittal is a respected jurist known for his legal acumen and decades of service to Indian judiciary. He earned his BCom honors from Allahabad University in 1982 and completed his law degree from Chaudhry Charan Singh University, Meerut in 1985. He was appointed as the additional judge of the Allahabad High Court in 2006 and made permanent in 2008. Justice Mittal later served as the Chief Justice of the High Courts of Jammu and Kashmir and Ladakh in 2021 and Rajasthan in 2022. In February 2023, he was elevated to the Supreme Court of India. With over 37,000 verdicts to his name, his judgments span areas like housing, banking, labor, and succession. His book, The Birth and Life of High Court of Judicature at Allahabad, remains a notable contribution to the judicial scholarship. We are truly privileged to have such a distinguished jurist among us today. Can we have a huge round of applause for Sir?
We kindly request Honorable Justice Shri Vivek Agrawal Sir to kindly join us on the dais. We also have Honorable Justice Shri Suresh Kumar Kaid, Chief Justice of the High Court of Madhya Pradesh and Chancellor of National Law Institute, University, Bhopal, as a guest of honor for the day. Justice Kaid holds a graduate degree in Humanities from University College, Kurukshetra, and a postgraduate degree in Political Science from Kurukshetra University. He pursued law at Campus Law Center, University of Delhi, and was enrolled as an advocate in 1989, becoming the first in his family to join the legal profession. As an advocate, he served as panel lawyer and senior counsel for the Union Public Service Commission and Indian Railways, and was appointed standing counsel for the central government in 2004, a position he held until his elevation to the bench. Justice Kaid was appointed as an additional judge of the Delhi High Court in 2008 and became a permanent judge in 2013. He went on to serve at the High Court of Judicature at Hyderabad for the states of Telangana and Andhra Pradesh before he returned to the Delhi High Court in 2018. In September 2024, he was appointed as the 28th Chief Justice of the Madhya Pradesh High Court. We are truly honored by his presence today.
At the heart of every institution lies a visionary leader. So we would like to introduce you to Professor Dr. S. Surya Prakash, Vice Chancellor of National Law Institute, University, Bhopal. He is a distinguished figure in the legal sphere whose dedication to advancing legal education serves as an inspiration to us all. He has more than 30 years of experience in academics and has held various posts such as serving as the Founder Vice Chancellor of NLIU Aurangabad, as the Vice Chancellor of DSNLU Vishakhapatnam, Principal of DNR College of Law, Andhra Pradesh, and faculty member of NUJS Kolkata and NLIU Bhopal. Additionally, Sir is a prolific writer who has authored several books and articles on multiple contemporary issues. He penned his first book on bonded labor and social justice, along with Turning Point, the story of a law teacher, which serves as the biography of Professor N.R. Madhav Menon. He serves, his areas of interest encompass jurisprudence, ADR, international commercial arbitration, labor laws, and health law. We are truly honored to have you with us today. Can we have a huge round of applause for Sir?
We also have with us today Honorable Justice Vivek Agrawal as our guest of honor. He currently serves as a judge of the Madhya Pradesh High Court. Born in Kasaganj, Uttar Pradesh, he began his judicial career in 2016 and has since served at both the MP and Allahabad High Courts. Known for his expertise in civil and constitutional matters, he is widely respected for his balanced and reasoned judgments. So we are truly honored to have with us today. As we begin this inaugural edition of the Conclave, we uphold the cherished tradition of lighting the ceremonial lamp, a symbol of wisdom, knowledge, and progress. I now invite our esteemed dignitaries on the dais to kindly step forward for the lighting of the lamp.
Thank you. At the center of today's conclave stands the Student Bar Association of National Law Institute, University, Bhopal. It serves as the voice of the student community and plays a crucial role in bridging the gap between administration and the student body. Since its inception in 2020, SBA has consistently worked to uphold its mission of service and leadership. This conclave is a testament to that mission, and it is a space for legal dialogue and meaningful collaboration between the bar, bench, and academia. We are proud to witness this movement where SBA transforms its idols into an event that aspires to shape the discourse of law and justice in India. Moving forward, as a gesture of our deepest respect and appreciation, we take this opportunity to extend a floral welcome to our esteemed dignitaries for their invaluable presence and contribution to the event. I would like to request our Vice Chancellor, Sir, to welcome our Chief Guest, Honorable Justice Shri Pankaj Mittal, Judge, Supreme Court of India and Visitor, NLIU, Bhopal. Thank you, sir. I would like to request Vice Chancellor, Sir, to welcome our guest of honor, Honorable Justice Shri Suresh Kumar Kaith, Chief Justice of the High Court of Madhya Pradesh and Chancellor of NLIU, Bhopal. Thank you, sir. I would now like to request, sir, to welcome our guest of honor, Honorable Justice Vivek Agrawal. Thank you, sir. I would now like to invite Mr. Yashpal Jhakar, President, SBA, to welcome Vice Chancellor, Professor Dr. S. Surya Prakash.
Thank you. I now kindly request the presence of our esteemed Vice Chancellor, Professor Dr. S. Surya Prakash, whose profound insights have consistently inspired the NLIU community. I humbly invite our Vice Chancellor to deliver the welcome address.
Judge, Supreme Court of India and Visitor, NLIU, Bhopal. Today's guest of honor, Honorable Justice Suresh Kumar Kaith ji, Chief Justice, High Court of Madhya Pradesh and Chancellor, NLIU, and the spirit and always giving guidance to NLIU, Honorable and Member of General Council, Honorable Justice Vivek Agrawal ji, Judge, High Court of Madhya Pradesh, and the invitees, Honorable Justice Banur Madji, former Chief Justice, High Court of Kerala, former Chairman, Human Rights Commission, Maharashtra, Honorable Justice R.M. Bodeji, former Judge, High Court of Bombay, Honorable Justice K.G. Shankar, former Judge, High Court of Andhra Pradesh, and many learned professors of NLIU from Barkala University, Madam, and many other dignitaries, student friends, and all other judicial officers and friends from the media, both print and the electronic media. My friends, today it is a great occasion, great moment for NLIU Bhopal because the SBA, Student Bar Association of NLIU, has initiated the program Law Conclave 2025. This is the first edition, and the Student Bar Association wants to commemorate 75 years of the Supreme Court of India. So, my friends, I congratulate Yashpal Dhankar, the SBA President, and all his team members for conceptualizing this event, and of course supported by the Professor Rakarya, the Dean Student Welfare, and other faculty members. Here I would like to tell only two things. When we are thinking about the Supreme Court of India, obviously we have to think about the Constitution of India, because the Supreme Court is the creation of the Constitution, and it is the obligation of the Supreme Court to protect the Constitution, that is, the values, the fundamental rights, and the morality of the Constitution of India. I would like to bring to your kind notice only two things, not a big deal. One about the Constitution, and then about the Supreme Court of India. What my teachers told me, Professor K. Gupteshwar and others, when we think about the Constitution, when we think about India, India is not a mere map on the paper, it is its people. When we think of people of India, what the great visionary and the chairman of drafting committee chairman, Dr. Baba Sahib Ambedkar, started the Constitution with 5 pious words, that is, we the people of India. And when we consider that we are the people of India, and when we do not identify ourselves with any other, either region, religion, caste, creed, any other thing, then only nation will progress. And particularly for my young generation, my young friends, because you happen to be the future of this nation, please identify yourselves as Indians and recognize and see others as Indians, nothing less and nothing more. Then only this nation will progress. Because in India there are so many divisive forces, and we should not be a victim of those divisive forces, and we should respect and we can pay real homage to the Constitution of India only when we can think of that we are Indians and Indians only. This is what the message from the Constitution of India, which I received from my teachers. And the second thing about, because we are commemorating 75 years of the Supreme Court of India, I would like to draw your attention on the tagline of the logo in the Supreme Court of India. What is the tagline? Yeah. So our student friend, Siddharth, he is very much aware, and many of our alumni student friends are also here. And you're right. And from where this line was taken? Mahabharata, very good. From Mahabharata, who said this to whom? No. So, no. Huh? Gandhari. So, this was, as usually, before going to battle, every son go to his mother to seek her blessings. So, Duryodhana also went to see his mother, Gandhari, to seek her blessings. And what I was told that this will come in different contexts, and one context where it was very famous, it was the context of conversation between Duryodhana and mother Gandhari. And we know that Duryodhana, he was the most beloved son of Gandhari. So when Duryodhana went to seek her blessings, normally, if an average Indian woman, what she will say, Jeeta raho beta, sabko maar dalo, and you should win. So normally this should be the blessings, nature of blessings by mothers. But she didn't say like that. She said, Yato Krishna, tato dharma, yato dharma, tato jaya. Where there is dharma, victory is always to dharma. And this line was taken from Mahabharata, was inscribed in the logo of the Supreme Court of India. That means that it's a message how objective when the institution of Supreme Court was created. Of course, Federal Court was transformed into Supreme Court, that's a different story. But when our forefathers, they have visualized that there should be a guidance for the bar and bench. That is, yato dharmasya tato jaya. That is, don't bother who was standing before you, whether he is a billionaire or a pauper, or whether he is an attender or he is an officer, or a big politician, powerful politician. The courts should look at objectively, as they are only the parties contenders for justice. Dharma should prevail. Needless to say that all our activities, they revolve around our thinking, our conscience, it revolves around Dharma. And in my considered opinion, if at all there should be a statue of Goddess of Justice in the Supreme Court of India, it should be the statue of Gandhari. She was blindfolded, but we should revere her what and how she has blessed her son. It should be victory to Dharma. With these few things, I'm very happy that many dignitaries, judges, and our own alumni has come from different places, Delhi, Bombay, and my teacher, Professor A. Lakshmanath, is also sitting here, who has an experience of more than 50 years in teaching Constitution, and who has produced more than 100 PhDs only in Constitution. So just you can think of his eminence. So even though he was 80 plus, all the way he made it, and similarly Professor Madhusudan Rao and Honorable Justice Banurma, Justice Bode, who has a lot of interest in academics, which made them to travel long distances in a short time and to make this. And your active participation will make this event a grand success, Law Conclave. And once again, I congratulate my SBA for organizing this wonderful. We are only supporting them, but the entire event, it was shaped by the SBA and the members of Student Bar Association NLIU Bhopal. With these few words, I welcome you once again. Thank you very much.
Thank you, sir. As we move forward, we would like to express our deepest appreciation through a traditional gesture of respect. We are in the heartland of Malwa, where the legacy of Raja Bhoj still echoes. A king known for his unparalleled wisdom, generosity, and cultural patronage. It is only fitting that we honor our distinguished guests in a manner that reflects the same values. In furtherance of the same, we are delighted to present the dignitaries with the commemorative memento of Raja Bhoj. We are also delighted to present a handmade shawl symbolizing both the warmth of our welcome and rich heritage of Bhopal. I kindly request Vice Chancellor Sir to present the token of appreciation to Honorable Justice Shri Pankaj Mittal. Thank you, sir. I kindly request Vice Chancellor Sir to present memento and shawl to Honorable Justice Shri Suresh Kumar Kaid. Thank you, sir. I kindly request Vice Chancellor, sir, to present the token of appreciation to Honorable Justice Shri Vivek Agrawal, Judge of High Court of Madhya Pradesh. Thank you, sir. I now invite Mr. Yashpal Jhakar to present the memento to Vice Chancellor Professor Dr. S. Surya Prakash. Thank you. To share the vision initiative, I now invite Mr. Yashpal Jhakar, President, Student Bar Association.
Respected dignitaries on the dais, esteemed faculty members, distinguished guests, and my dear friends, a very good morning to all of you. It is with great pride and immense gratitude that I, Yashpal Jhakar, President of the Student Bar Association, stand before you today on the occasion of the first NLIU SBA Law Conclave, a historic moment for our university and indeed a first of its kind event across the national law universities. Our university has consistently been ranked among the top 3 NLUs in the country. This recognition is not merely a matter of rankings, but a reflection of our unwavering commitment to academic excellence, holistic student development, and progressive institutional values. We at NLIU offer state-of-the-art academic infrastructure, excellent placement record, a vibrant culture of co-curricular achievements, and well-developed sports and medical facilities, and one of the most progressive student welfare policies in the country, which has been acknowledged by the law schools across the country. These features, coupled with an active and empowered student bar association, create a nurturing environment that supports both intellectual and personal growth. True to our university's motto, Yatnavan Sukh Medte, means a person who strives hard gets happiness. This conclave is a testament to the dedication and collective effort of the student body. The law conclave that we inaugurate today with the motto Bar, Bench and Beyond is the product of a vision that took shape a year ago. The motto reflects our intent to explore evolving dynamics between the legal profession, the judiciary, and the broader societal context within which they function. What began as an idea to create a platform for legal discourse, policy dialogue, and student engagement soon transformed into a mission embraced by the entire student body of NLIU. Throughout this journey, we have been fortunate to receive constant encouragement and support from our Honorable Vice Chancellor, sir, our Dean Student Welfare, Raka ma'am, and all esteemed faculty members. This conclave is not just an event, it is a celebration of student initiative, institutional support, and a shared aspiration for academic rigor, reformative dialogue. We hope it will serve as a space where ideas are exchanged, perspectives are challenged, and new learnings emerge. For students, this is an opportunity to interact with some of the most respected voices in the legal fraternity and to live inspired, informed, and invigorated. On behalf of the Student Bar Association of NLIU Bhopal, I extend my heartfelt thanks to our honorable dignitaries for gracing us with their presence and for their continued commitment to the growth of NLIU. We look forward to their insights, their blessings, and their vision for the future of legal education in India. Let this conclave mark the beginning of a new tradition of thoughts, dialogues, and student-led excellence. Thank you so much.
Thank you, Yashpal. It is with great pleasure that I invite our esteemed guest of honor, Honorable Justice Vivek Agrawal, Judge, Madhya Pradesh High Court, to take the podium and inspire students.
Judge, Supreme Court of India, and Chancellor NLUI Bhopal, Honorable Justice Suresh Kumar Kaid Sahab, Chief Justice Madhya Pradesh High Court, Shri Surya Prakash Ji, Vice Chancellor NLUI Bhopal, Justice Manohar Math, Chief Justice Kerala High Court, former Chief Justice Kerala High Court, former judges Justice Borde, Justice Shankar, professors, lawyers, and dear friends. I have been taken by surprise, both in the sitting arrangement as well as invitation to speak. But what I understand that, first of all, I should congratulate Student Bar Association for organizing this function and for their vision to think of 75 years of working of the Supreme Court. I think this is a very important milestone in 2025, and there can be 2-3 ways to look at the working of the Supreme Court. As a student of law, I would like to divide it decade-wise and wish that students understand and research that what has been the progression of Supreme Court with the progression of the society and governance from 1950 to 2025. This can also be done, if possible, by dividing the Supreme Court judgments in 3 eras of each quarter, 1950 to 1975, that is the time when emergency was imposed, and that was a watershed era for Supreme Court, and from 75 to 2000 and 2000 to 2025. I think that if this approach is adopted, then it will give a new vision to understanding the working of the Supreme Court. Working of the Supreme Court and its understanding is necessary to serve the people of the country. I think that all the judicial institutions, be it Supreme Court, High Court, or District Judiciary, now have to remodel their approach, and we are required to act as a service provider to the people of India. And therefore, I think that the motto of bar, bench, and beyond should also be modified in future times to come: people of India and the role of bar and bench to serve people of India. I think with this approach we can achieve a lot. Thank you very much.
Thank you so much, sir. It is with great pleasure that I now invite our esteemed guest of honor, Honorable Justice Shri Suresh Kumar Kaid, Chief Justice of the Madhya Pradesh High Court and Chancellor of NLIU Bhopal, to share his wisdom with the gathering.
Excellent human being, outstanding judge, my Lord Justice Pankaj Mittal, Judge Supreme Court of India, my esteemed colleague Justice Vivek Agrawal, Professor Surya Prakash, Vice Chancellor of this university, the retired judges, former judges of the different high courts sitting in the first row, their spouse, the faculty members, member of the bar, judicial officers, President and his team of the student union, dear friends, ladies and gentlemen. It is an honor to stand before you today as the Chancellor of this prestigious institution, the National Law Institute University, Bhopal, on the occasion of first NLIU SBA Law Conclave. Today is more than just a formal gathering. It is a celebration of thoughts, dialogues, and the collective spirit of inquiry that defines the legal profession at its best. At the outset, I wish to express my sense whose initiative and dedication have brought this conclave to life. The choice of motto, bar, bench, and beyond, is both profound and timely. It asks us not only to examine the role of legal profession as it stands today, but to imagine the direction in which it must grow with integrity, innovation, and inclusivity. Having recently marked the 75th anniversary of the Supreme Court of India in 2024, we find ourselves reflecting on a remarkable judicial journey. In this context, the theme of the conclave could not be more apt. In these 7.5 decades, the Supreme Court has emerged as a sentinel of justice, a guardian of constitutional morality, and a dynamic institution that has adapted to the its aspiration of a changing society. It has shaped the moral and legal fabric of our democracy, navigated complex transactions, and ensured that the voice of the Constitution reaches even in the most distant corners of this nation. Let us also acknowledge the high courts across the country, which have ably supported the Supreme Court in the dispensation of justice, ensuring timely and effective adjudication at the state level. In that light, this conclave becomes especially significant. It provides a platform for students, scholars, and practitioners to engage with the very question that will define the next phase of legal evaluation in India. As student of law, you are at a unique point in your journey. You are preparing not just for a career, but for a lifelong commitment to justice. Law is not merely about statutes and procedure. It is about empathy, reasoning, and the pursuit of fairness. It demands not only academic rigor, but also the courage to question, the patience to listen, and the humility to grow. The motto, bar, bench, and beyond, invites us to reflect on where we stand, how we correct, and where we can go from here. The bar represents the role of lawyers, a space where speaking with honesty and strong reasoning can influence decisions, and where lawyers have the duty to stand for the truth even when it is difficult. The bench symbolizes wisdom, restraint, and interpretation, where judgments rest on charity, balance, and justice rather than mere power. Beyond challenges us to look ahead to see how law interacts with society, technology, the economy, governance, and global challenges, and to embrace our role as agents of transformation. I'm informed that this conclave will host several panel discussions, each focusing on key themes that trace our constitutional journey and point towards its future. These includes the structure of our constitution, the evaluation of fundamental rights, the dynamics of judicial intervention, the protection of religious liberties, the emergence of digital challenges, and the Supreme Court's wider impact on society. Each theme is a vital conversation about the values that bind us, the changes we must embrace. What is most heartening is that this conclave is led by students. That, to me, is the greatest sign of progress. When students take the initiative to organize platform of thoughts, dialogues, and critical engagements, it means that the future is in safe and capable hands. If reflects a legal education that is not beyond by classrooms, but enriched by conversation, collaboration, and creativity. NLIU Bhopal, over the years, has consistently demonstrated a commitment to academic excellence and innovation. Its students, faculty, and alumni continues to contribute meaningfully to legal scholarship, practice, and reforms. I commend the university's efforts to foster an environment where legal education is not static but dynamic, not just for competitive but also compassionate. As we look forward to celebrating Ambedkar Jayanti on Monday, 14th April, this conclave, through its academic and legal rigor, stands as a fitting tribute to the architect of our Constitution, Dr. B.R. Ambedkar. As Chancellor of this university, I take immense pride in the fact that events like this conclave showcase the true potential of legal education to inspire, to interrogate, and to innovate. It is in gatherings like these that the next generation of thought leaders is shaped, not just by what they learn, but by how many they think and how they listen and how they respond to the challenges of our times. To all the students and participants here today, I urge you to approach this conclave with an open mind, engage with curiosity, and most importantly, listen with sincerity. Do not shy away from difficult questions. The strength of law lies not in avoiding complexity, but in embracing it with integrity and purpose. With that, I once again extend my heartfelt congratulations to the organizers and my best wishes to every participant. May this conclave be the beginning of many more such spaces of learning and leadership. And may your journey through law take you beyond the bar and bench into a very heart of justice itself. Thank you very much. Jai Bharat.
Thank you, sir, for your insightful words. It is with immense honor and deepest regard that we now invite our chief guest, Honorable Justice Shri Pankaj Mittal, Judge of Supreme Court of India and visitor NLIU Bhopal, to deliver the keynote address.
वंदे वाणी विनायको। सभी को मेरा नमस्कार। Office bearers and the members of the Students Bar Association, Brother Justice Suresh Kumar Kaith, Chief Justice Madhya Pradesh and Vice Chancellor of the University, Professor Dr. S. Surya Prakash, Vice Chancellor, members of the bar, distinguished scholars, honored guests, my fellow colleagues, faculty members, and dear students. It is an honor to stand before you today at this distinguished gathering to mark a truly historic milestone, 75 years of the establishment of the Supreme Court of India. This occasion, while celebratory in spirit, is far from ceremonial in purpose. It invites us to pause, not merely to recount institutional achievements, but to reflect with candor and conviction on the journey of a court that has, for 7.5 decades, shaped the legal and the constitutional character of this republic. 75 years is not a mere sequence of dates or a numerical tally of decisions rendered. It is a passage through transformative era, through evolving jurisprudence, social transitions, and constitutional rediscoveries. The story of the Supreme Court of India is not just confined to volumes of case law. It is written into democratic ethos of the nation, into every affirmation of liberty upheld, every voice protected, and every injustice redressed. Since its first meeting on 28th of January 1950, with a modest bench of 6 judges, the Supreme Court has grown in strength and structure and also in moral stature. From its early days in the chamber of the old Parliament building to its present address, the Supreme Court has become a symbol of hope and a space where constitutional ideals come to life. Its mission has remained steady to interpret the Constitution as a living document, responsive to the complexities of a changing society and at the same time remaining committed in principle. It is this fine balance between adaptability and fidelity that has defined the Supreme Court's continuing relevance. As we have gathered today, let us remind ourselves that the majesty of justice does not rest in the symbolism of robes or the scale of courtrooms. It lies in the people's belief that judiciary will act with integrity and courage and will remain an impartial guardian in the face of competing powers and shifting political currents. Around the world, democracies are confronting new and formidable tests, rising inequality, rapid technological change, and developing polarization. India too is not untouched by these currents, yet in the midst of such flux, the Supreme Court has stood as a stabilizing institution by upholding the rule of law. It is in this spirit that we must now turn to deeper roots of our legal tradition to understand how the modern Constitution draws from a moral reservoir far older than its own text. For the judiciary of Indian justice, story of Indian justice does not begin in 1950. It is rooted in something more ancient, yet remarkably enduring. The concept of justice in Indian tradition is not a recent invention. Long before the language of modern jurisprudence took form, the subcontinent had developed a rich moral vocabulary around justice, duty, righteousness, and governance. Justice, in our civilizational understanding, is the embodiment of dharma, a principle that encompasses ethical conduct, social responsibility, and the rightful exercise of power. Dharma, in its essence, is more than a rule, it is a restraint. It demands that those who wield authority do so not for personal gain or arbitrary will, but in alignment with the higher sense of duty and fairness. It insists that government must be animated by humility and that legitimacy of power rests on its capacity to serve. The ancient understanding finds enduring expression in the very motto of the Supreme Court of India, Yato Dharmaso Tata Jaya. Where there is dharma, there is victory. Professor has already told you how this motto came to be picked up from the Mahabharata. In fact, while preparing for the battle, Duryodhan wanted to have the Ashirvad of his mother, but he went to her in a very casual manner. लड़ाई के लिए जाना है, माँ का आशीर्वाद लेना है, एक फॉर्मेलिटी के तौर पे वो जो हैं माँ गंधारी के पास जाते हैं, लेकिन वो भरे हुए थे कि मुझे तो युद्ध करना है, युद्ध जीतना है, और बिना ये ध्यान दिए कि माँ ने क्या आशीर्वाद दिया है, वो युद्ध पे चले जाते हैं। और माँ गांधारी इतनी समझदार थीं, तो उन्होंने ये नहीं कहा पुत्र विजयी भव, उन्होंने कहा पुत्र चिंता मत कर, जहाँ धर्म है वहीं विजय होगी, यथो धर्मस्य तथो जया। और इस वरदान को लेके, इस आशीर्वाद को लेके दुर्योधन जो है महाभारत के युद्ध में उतरा, और वही हुआ जो माता गांधारी ने कहा था, जहाँ धर्म था वहीं जीत हुई। एक और इसके साथ कहानी है, युद्ध से पहले दोनों पक्ष, पांडव भी और कौरव भी, भगवान कृष्ण के पास जाते हैं मदद मांगने, उनका आशीर्वाद लेने। भगवान कहते हैं मैं तो न्यूट्रल रहूँगा, मैं तो तटस्थ हूँ, मैं शस्त्र उठाऊँगा नहीं। अब एक तरफ मैं हूँ और एक तरफ मेरी नारायणी सेना है, बहुत बड़ी नारायणी सेना थी। तो दुर्योधन ने नारायणी सेना मांगी और युधिष्ठिर पांडवों ने खुद केशव को मांगा। अब जहाँ केशव होंगे वहीं तो धर्म होगा और वहीं विजय होगी। यही वरदान था माँ गांधारी का, यतो धर्मस्य ततो जया। Our constitution is therefore a moral declaration, a compact between the state and its people, that governance shall be exercised with compassion, with equity, and with reverence for the dignity of each human life. And it is the Supreme Court of India that has been vested with the responsibility of safeguarding that promise. The court's role is to ensure that constitutional morality triumphs over executive expediency, that justice is not sacrificed to political convenience, and that the rule of law is not rendered to a rule of power. The rule of law is not reduced to the rule of power. This the Supreme Court has to ensure. This task is not easy. It never has been. Each generation faces the same dilemma: how to hold fast the principle in time of pressure, how to honor tradition while embracing transformation. Yet the principle of dharma continues to guide our path as a living, breathing framework for justice in the present. In the early decades, the court focused on building the edifice of constitutional law. A.K. Gopalan case, 1950, showed initial deference to the state power, but the tide began to turn with Golaknath, and then dramatically with Keshwanand Bharti in 1973. In Keshwanand Bharti, the court laid down that the basic structure doctrine ensuring that Parliament could not alter fundamental identity of the Constitution. It was an odious act of judicial courage unmatched in the constitutional jurisprudence of any other country. This monumental marked the transition of the court from being a mere interpreter of the Constitution to its vigilant guardian. During the dark days of emergency, the infamous decision in ADM Jabalpur momentarily betrayed this legacy, but the court later redeemed itself, acknowledging its mistake and confirming in Menka Gandhi the expansive and the dynamic interpretation of the right to life and personal liberty under Article 21 of the Constitution. Since then, the Supreme Court has never looked back. It has struck down constitutional amendments in Minerva Mills and Colio, invalidated executive actions and policies in Arjun Gopal and Common Cause case, and constantly reminded the government of its constitutional limits. Whenever the call for social justice has echoed through our democracy, the Supreme Court has responded with empathy, courage, constitutional clarity. In Shahbano's case, the court upheld a divorced woman's right to maintenance, affirming that dignity transcends personal law. In Vishakha, the Supreme Court laid down foundation for protecting women against workplace harassment long before statutory safeguards. In Olga Tellis, the Supreme Court gave voice to the pavement dwellers, declaring that the right to livelihood is inseparable from right to life. In D.K. Basu, the apex court revisited the criminal procedure by setting vital safeguards against custodial torture and procedures of arrest. In each case, the court stood as the conscious keeper of the Constitution. As the court continued this march towards justice, its most powerful moment came when it lent its ear to the voiceless, fameless, nameless, by opening the doors of the Supreme Court to the letters petition in public interest. In Husainara Khatun, it brought light into the dark cells of the unforgotten under trials prisoners, reminding the nation that the liberty cannot wait behind the bars. Through MC Mehta, the court taught us that the environment is not a luxury, but a right, and that those who pollute must pay. Justice Bhagwati and Justice Krishna Iyer transformed the Constitution through PILs, opening the doors to the pure, the marginalized, and the silenced. making justice not a privilege, but a lived and shared reality. Beyond case law, the court's general approach to environmental procedure too has drawn from ancient Indian thought. In M.C. Mehta, T.V. Godavarman, the court spoke of the intrinsic value of nature, the concept of Prakritik, nature, being sacred and man being its custodian is deeply rooted in the Vedas. The Atharvaved calls upon humanity not to harm the sky, the earth, the air, the water, or the forest. These ideas find judicial translation in the public trust doctrine and sustainable development. हमारे शास्त्रों में धरती माता को माता कहा गया है, माँ भारती हम कहते हैं। प्रकृति जो है यही हमारी माता है, उसी की गोद में पल बल के हम लोग बड़े होते हैं। अब जब प्रकृति हमारी माता है, धरती हमारी माता है, तो किसी बच्चे को उसकी माँ से अलग नहीं किया जा सकता। वो बच्चा माँ की गोद से अलग नहीं पनप सकता। इसलिए शुरू में, प्रारंभ में माता बच्चे का लालन पालन करती है और एक समय आता है जब उस बच्चे को बड़े होके अपनी धरती का, अपनी माता का देखभाल करनी चाहिए। यही एक प्राकृतिक का नियम है। हमें प्रकृति की रक्षा करनी चाहिए और जितनी ये जो एनवायरमेंटल जूरिस्प्रूडेंस है, नेशनल ग्रीन ट्राइब्यूनल है, ये इसी डॉक्ट्रिन पे बेस्ड है कि एक माँ को बच्चे से अलग नहीं करना है और बच्चे की ही जिम्मेदारी है कि बड़े होकर वो अपनी माँ की रक्षा करे, प्रकृति की रक्षा करे। Even the idea of Lok Adalat, institutionalized by Legal Services Authorities Act, echoes the village-based justice system of ancient India, the panchayats and the sabha system, as described in the Arth Shastra and the Manusmriti, aimed at restorative and constitutional justice. The goal was reconciliation, not arbitration. The Supreme Court has repeatedly encouraged alternative dispute resolution in civil and matrimonial cases, echoing this ethics. Judicial independence is another important facet. It is the soul of the democracy that seeks to protect every citizen, especially the powerless. The journey began with S.P. Gupta versus Union of India, the judge's first transfer case, where the executive held primacy in political appointments. In Supreme Court Advocates on Record Association, special reference number 1 of 1998, the second and third judges' cases, the court reclaimed this power to protect its own independence. In Supreme Court Advocates on Record Association versus Union of India, it struck down the NJAC not to resist reform, but to preserve the core of judicial autonomy. Yet, it also recognized the independence must walk alongside transparency, for public trust is built through both integrity and openness. In its finest moments, the Supreme Court has acted not just as a court of law, but as a court of conscience. It is easy to speak of the Constitution and its modern liberal values, but in truth, Indian constitutionalism did not arise in vacuum. The moral foundation of Indian jurisprudence is older than 1950. It is even older than 1947. It is rooted in millennia of civilizational wisdom recorded in the Vedas, Smritis, Dharma Shastras, Arth Shastra, and Buddhist texts, and the grand epics of Ramayana and Mahabharata. Dharma, perhaps the most profound and complex Indian legal concept, predates the term law in our lexicon and Black's Law Dictionary. While Western legal systems often draw a hard line between law and morality, ancient Indian jurisprudence understood dharma as a unifying principle of righteousness, justice, duty, and harmony. The Supreme Court's work often mirrors this unity of legal rule and moral vision. In fact, Article 51A of the Constitution, which lists the fundamental duties, reflects ancient Indian ethical ideals: truth, compassion, respect for elders, and reverence for knowledge and natural world. अब हमारे कॉन्स्टिट्यूशन में फंडामेंटल राइट्स शुरू से थे. उस समय फंडामेंटल ड्यूटीज़ का उसमें कहीं जिक्र नहीं था. फंडामेंटल ड्यूटीज़ बाद में लाई गईं. ये एक तरीके से देखा जाए तो हमारे धार्मिक एथॉस के बिल्कुल विपरीत था. त्रेता युग में भगवान रामचंद्र आए. उन्होंने हमें कर्तव्य करने का बोध कराया. कर्तव्य करो. बेटा पिता के प्रति कर्तव्य कर रहा है, भाई के प्रति कर रहा है, पत्नी के प्रति कर रहा है, दुश्मन के भी प्रति कर रहा है, गुरु के भी. कर्तव्य करो. उसके बाद द्वापर में भगवान श्री कृष्ण आए, जिन्होंने अधिकार के लिए लड़ना सिखाया. अधिकार के लिए लड़ना क्यों सिखाया? कि अगर कर्तव्य करने के पश्चात भी आपको आपका हक नहीं मिल रहा है तो शांत नहीं बैठना है, तो आपको लड़ना है. कर्तव्य निभाने के बाद अधिकार की मांग करना, ऐसा ही आज रिट जुरिडिक्शन में हम रोज कहते हैं, कम विद क्लीन हैंड्स क्लीन माइंड. हर किसी के लिए रिट अवेलेबल नहीं है, लेकिन हमारे संविधान में ये जो ड्यूटीज़ हैं ये बाद में आई, लेकिन आई. आज ये ड्यूटीज़ हैं, मे बी बहुत एनफोर्सेबल इन लॉ नहीं है, परंतु हम लोग उससे गवर्न होते हैं और हमारे अधिकारों की व्याख्या उसी पर निर्भर करती है. Let us recall the principle of samatva, equality, which finds resonance in both Vedic texts and the Purans. The Rig Veda states, let no one be superior, let no one be inferior. All are brothers walking on the same path. This principle of equality, which we talk about today, it is in existence for times immemorial. The Supreme Court's protective role in affirmative action jurisprudence, including in Indira Sahni, can be viewed through this lens of intrinsic human equality, rooted not only in Article 14 of the Constitution, but also in India's ancient agrarian spiritual ethos. In A.S. Narayana, Justice Hansaria wrote something truly profound. He said that our dharma, which we may today call our legal or moral order, is sanatan, eternal. It is not bound by time or by place. It is in many ways a living, breathing philosophy. The Rig Veda captures this beautifully when it refers to Sanatan Dharma principles that endure generation after generation. But let us pause here. What is dharma? It is not simply a rule book. It is something far deeper. It means to uphold, to support, to nourish, to, like their Western counterparts, often wear multiple heads as moral guides, social reformers, and judicial statesmen. We visualize the Constitution not just as a break from the past, but as a bridge between the ancient values of dharma and the modern vocabulary of rights. He famously said that our Constitution does not shut out the past. It embraces the past and transforms it. In my capacity as a visitor to this esteemed university, I would now like to offer a humble but a firm recommendation. One that arises not just from the personal reflection, but from the lessons of history and jurisprudence we have explored today. It is time that our law schools formally incorporate the ancient Indian legal and philosophical traditions into the curriculum. The Vedas, the Smritis, the Arthashastra, the Manusmriti, the Dhammas, and the epics of Mahabharata and Ramayana are not merely cultural artifacts. They contained deep reflections on justice, equity, governance, punishment, reconciliation, and moral duty. Their duty is indispensable if we are to understand the roots of Indian legal reasoning. I propose that the law colleges and universities introduce at least one dedicated subject that expresses these ancient concepts, perhaps under the title Dharma and Indian Legal Thought or Foundations of Indian Legal Jurisprudence. This course should not be confined to a textual reading but must draw connections between classical Indian ideas of justice and their modern constitutional reflections. Such a subject would not only provide students with cultural and intellectual grounding, but also help shape a uniquely Indian jurisprudential imagination. Just as Western students read Roman law and colonial texts of legal philosophy, Indian students must become conversant with the juristic ideas of Yaglabban, Kautilya, Manu, and Ashoka. This is not a project of nostalgia, it is a project of rooted innovation. Imagine a generation of lawyers and judges who understand Article 14 not just as a borrowed principle of equality, but also as an embodiment of samatva, who viewed environmental law not just through statutes, but through the reverence for Prakritik in the Vedas, who understand alternative dispute resolution as a continuation of panchayat traditions, and who grasp constitutional morality as a modern articulation of ancient Raj Dharma. This curricular reform would serve a deeper constitutional goal, the preservation of India's pluralistic legal identity. It would reinforce the idea of Indian constitutionalism is not merely an import, but a living constitution of a civilizational legacy. Recently, our Supreme Court thought of Indianizing the judicial system. Justice Chanchud, through the help of artificial intelligence, he got all the judgments of the Supreme Court translated into Hindi and various other Indian languages. And the work is entirely, I think it is over now. All judgments have been translated. Now this is a step towards judiciary ka bhartiyakaran, Indianization of judiciary. और इसी परिप्रेक्ष्य में उन्होंने जो ये न्याय की देवी है उसके स्टैच्यू में भी कुछ बदलाव करे और हमारी जो सुप्रीम कोर्ट की लाइब्रेरी है उसमें एक नई मूर्ति उनकी लगाई स्टैच्यू ऑफ जस्टिस की। उसमें वो एक इंग्लिश ड्रेस जो ट्यूनिक है उसको हटा के उसको साड़ी पहना दिया, आंखों पे से पट्टी हटा दी और हाथ में से तलवार हटा के एक पुस्तक दे दी। संभवतः वह पुस्तक हम कॉन्स्टिट्यूशन ऑफ इंडिया ही मानते हैं। तो ये जो हैं सब कदम जुडिशरी के भारतीयकरण की तरफ है। अब इसमें एक छोटा सा सुझाव मेरा और है, वो जब किताब एक दी है तो अगर वो 4 किताब हों, संविधान भी हो, साथ में गीता, वेद और पुराण भी हों, उसके परिप्रेक्ष्य में हमारे न्याय प्रणाली चले तो मैं समझता हूँ कि हम हर नागरिक को न्याय दे पाएंगे। Let us make our universities the temples of justice, of both modern learning and ancient wisdom. Let us train lawyers who are not only articulate in precedent but wise in tradition. As we stand here for the legal conclave conducted by the Students' Bar Association, we are not just witnesses to the legal institution's journey, We are participants in the evolution of a nation. The Constitution is a moral compass, but a compass is only useful if we have the courage to walk the direction it points at. The Supreme Court of India has often taken that first courageous step. It has spoken truth to power, it had heard the voiceless, it has confronted its own errors, it has adapted, evolved, and led. To the students here today, let me say that the Constitution is your inheritance, but justice is your responsibility. Let us honor this 75 years of journey, and not just by remembering its milestone, but walking boldly into the future with our roots in the past, our eyes on the horizon, and our hearts steadfast in the pursuit of justice. I repeat, but by walking boldly into the future with our roots in the past, our eyes in the horizon, and our hearts steadfast in the pursuit of justice. Thank you. Jai Hind, Jayati, Jayati, Jayamam Bharatam.
Thank you so much, sir. Today marks another significant milestone for NLIU as we proudly unveil the inaugural edition of the NLIU Journal of Law and Technology, which is the flagship publication of the Cell for Law and Technology. Since its inception in 2019, CLT has been at the forefront of exploring the legal dimensions of emerging technologies. By engaging with policymakers, industry experts, and legal scholars, the Cell continues to shape the future of technology regulation in India. To officially launch this inaugural edition, I invite Professor Dr. Atul Kumar Pandey, Faculty in Charge, CLT, along with Ms. Rishita Sethi, Convener, and Mr. Hussain, Co-Convener, to join us on the stage. Can we have a huge round of applause, please? Thank you so much. As we conclude this inaugural ceremony, it is time to express our gratitude to those who made this event possible. To deliver the vote of thanks, I now invite the Secretary of the Student Bar Association, Mr. Priyanshu Gupta, to take the stage.
Good morning, everyone present here. My special honor to the dais for chief guest of this conclave, Justice Pankaj Mittal, Judge, Supreme Court of India and Visitor, NLIU Bhopal. Justice Suresh Kumar Kath, Chief Justice, High Court of Madhya Pradesh and Chancellor, NLIU Bhopal. Shri Justice Vivek Agrawal, Sir, Judge, High Court of Madhya Pradesh and Professor Dr. S. Surya Prakash, Sir, Vice Chancellor, NLIU Bhopal. It is with immense honor and gratitude that I, Priyanshu Gupta, Secretary of the Student Bar Association, NLIU Bhopal, on behalf of the SBA and entire NLIU family, extend the vote of thanks at the inaugural session of the first NLIU SBA Law Conclave. To begin with, I would like to express our deepest appreciation to Honorable Justice Pankaj Mittal, Judge, Supreme Court of India, for gracing us with his esteemed presence as the chief guest for the inaugural session. Sir, your presence has elevated the stature of this conclave, and your words have given us much to reflect upon as we celebrate 75 years of Supreme Court of India. We are equally honored by the presence of Honorable Justice Suresh Kumar Kath, Chief Justice of High Court of Madhya Pradesh, as the guest of honor. Sir, we're truly grateful for your inspiring address, and your continuous guidance to our university always motivates us to lead such discourse. We are also thankful to Honorable Justice Vivek Agrawal, Sir, Judge, High Court of Madhya Pradesh, for joining us today. Sir, your continued engagement with us and with the academic platform like ours is a source of immense encouragement to young minds. I also take the opportunity to extend a warm thank you to the dignitaries from Judiciary who have joined us here today, including honorable former judges from the high courts as well as respected members of the district judiciary. Your presence reflects the unity and shared purpose of Indian judiciary in upholding true justice and rule of law. A special word of thanks to our Vice Chancellor, Sir, Professor Dr. S. Surya Prakash, whose constant guidance and encouragement has played a crucial role in conceptualizing this conclave and ensuring its successful launch. We are also extremely thankful to all the distinguished scholars, senior advocates, academicians who will be contributing their knowledge and insights over the course of next 2 days as we look back at the remarkable journey of Supreme Court of India. We are reminded by the words of Justice V.R. Krishna Iyer, that is, law without justice is a wound without cure. This conclave is our humble effort to reflect on both the law and justice it seeks to serve. To the administration and the organizing team, faculty and staff members of NLIU family, we extend our heartfelt gratitude in conceptualizing this event. And finally, the most important part of this conclave, the student community. Thank you for being here in such large numbers. The energy and engagement you bring here, what makes this conclave meaningful. We are also grateful to the students, faculty members, and administrative representatives from law colleges across Bhopal who have joined us today. Your presence reaffirms the collective spirit of legal education and academic exchange. We hope that these 2 days not only leave behind the rich discussion and insightful takeaways, but also also a remarkable memory in the journey of everyone involved. Let this first NLIU SBA Law Conclave be more than just a gathering. Let it be a benchmark in the legal discourse that contributes meaningfully to the evolving legal landscape of our nation. Now, before I end my vote of thanks, I would like to extend special gratitude to our faculty advisor and Dean Student Welfare, Professor Dr. Raka Arya, for his continuous guidance without any consideration, providing us daytime efforts. Thank you so much, ma'am. With this, I end my words. Thank you once again. Jai Hind.
Thank you, ladies and gentlemen, for your gracious presence. With this, we declare the first NLIU SBA Law Conclave officially open. We now invite you to join us for the sessions ahead as we embark on a journey of legal insight and intellectual enrichment.
As we draw this inaugural session to a close, may I request everyone to please rise for the national anthem.
I request all the participants to be seated and kindly request all the faculties, resource person to please come on the stage for photograph. Thank you.
I request the SBA members to kindly come on stage for a photograph.
All the participants are requested to be seated. We will be starting our next panel discussion in next 15 minutes. Thank you so much. All the participants are requested to be seated. We will be starting our next panel discussion in 15 minutes. Thank you so much.
All the participants are kindly requested to please take seats. Participants who are seated at the back of the auditorium are requested to please occupy the front seats. We are shortly about to begin with the session. Thank you.
I kindly request everyone to please remain seated. We'll begin with the first panel discussion now. A very good afternoon to our esteemed dignitaries, respected faculty members, and students present here. It is my honor to welcome you to the first panel discussion of the NLIU SBA Law Conclave. Today, it is our privilege to host an extraordinary panel of guests. I extend a heartfelt welcome to Honorable Dr. Justice K.G. Shankar, former Justice, High Court of Andhra Pradesh, as our chair for the discussion. Professor Dr. A. Lakshminath, Distinguished Professor Emeritus, and Professor MNLU Aurangabad as our co-chair. Mr. Sankalp Kochar, Advocate MP High Court, and Mr. Biswajit Dubey, Additional Advocate General, State of Chhattisgarh, to kindly occupy the dais. It is a privilege to participate in this esteemed panel discussing the Supreme Court's role in shaping and safeguarding the basic structure doctrine in India. As a token of our heartfelt appreciation, we are privileged to present them with a miniature statue of Raja Bhoj, a symbol of enlightened leadership and timeless vision. Alongside, we offer a handmade shawl representing not just the warmth of their presence, but also the rich cultural heritage and enduring traditions of Bhopal. I kindly request our Honorable Vice Chancellor, Sir, to please facilitate the panelists. I request Vice Chancellor, Sir, to felicitate Honorable Dr. Justice K.G. Shankar. I request Vice Chancellor, Sir, to felicitate Professor Dr. A. Lakshminath. I kindly request Vice Chancellor, Sir, to felicitate Mr. Sankalp Kochar. I request Vice Chancellor, Sir, to felicitate Mr. Biswajit Dubey. I would now request the chair for the session, Honorable Dr. Justice K.G. Shankar, to commence the panel discussion.
Good morning, everyone, or perhaps I should say good afternoon. Professor Lakshminath Garu, young advocates who are in the panel, students, and other invitees, if anybody is present here. The 2 days program is known as 75 years of the Supreme Court, perhaps the March of Law. There are a lot of things for anyone to say about the Supreme Court, even for a layman. However, the Vice Chancellor was not very kind. He fixed subjects to each of us. When we are not expected to go at least far beyond. We may go a little bit, but we are not expected to go far beyond the subject that is assigned to us, each session. As far as this session is concerned, we are to deal with the basic structure. That is one of my very favorite subjects. I'm very happy that I am accommodated in this subject to interact with the students particularly. When we sat I had one confusion. Who used to speak first? Who used to speak second? Who used to do what? Then I conferred with all the learned other three members. Professor Lakshminath Garu made one suggestion. I should address first, then the two young lawyers, young in the sense, this boy has put up 17 years of standing, but as far as I am concerned, they are young. Not because of my age, because of the experience. Age is a different aspect altogether. Therefore, the two young lawyers would address each to the audience, and then Lakshminath Garu would take over. He would more or less, he would summarize the proceedings. Because I say more or less because I would again intervene at the end and say a few words before the session is completed. This is the way how we chalked out. But we are slightly running late. Would it be all right if we go till 1:30? 1:30. Till 1:30 it's all right. Right. First about the basic structure. Most of you are aware what is how the basic structure theory has evolved. But this constitutional views of the Supreme Court went like waves. First, of course, the Honorable Judge of the Supreme Court, I believe, he has referred to A.K. Gopalan's case. A.K. Gopalan's case, I can't say that it falls within the ambit of the amendment of the Constitution. The first of these cases was Shankari Prasad Singh Dev. In that, I think then there were 6 judges of the Supreme Court or 7 judges. I think 6 judges sat. The first Chief Justice, Kania, presided over, and ultimately it was held that more or less fundamental rights cannot be abridged. More or less, that is not the direct hit, but by and large that was the view that was taken in that case. Then came Sajjan Singh. In Sajjan Singh, I think Shankari Prasad Singh Dev, the funny part is it came in 1951. By then, the parliament was not constituted. There was no parliament as such. The Constituent Assembly ended its tenure when the Constitution came into force. It acted as provincial parliament, and it made the First Amendment with great respect. I call it rape of the Constitution by Jawaharlal Nehru and Ambedkar put together. The First Amendment brought the 9th schedule, where any law which is uncomfortable to the government, put it in the 9th schedule and say that nobody can question anything about this law. That was the aspect which came up for consideration in the Shankari Prasad Singh Dev. As I told you, that the Supreme Court held that constitutional amendment cannot abrogate or abridge fundamental rights. Then that Shankari Prasad, after Shankari Prasad Singh Dev, Sajjan Singh. In Sajjan Singh, the Supreme Court took a U-turn. It said Parliament has absolute powers. And that's why I said it's like a wave. Then the very famous Golakanath. Golakanath case, when we were students of law, we were asked to preferably read at least one of the judgments of the Golakanath case. In fact, I read 2 or 3 judgments of Golakanath case. Just when I joined law in December 1973. In April 1973, Kesavananda Bharati decision has come out. 1967, Golakanath emerged. In Golakanath, judges were almost equally divided. 5 judges each. The 5 judges said fundamental rights cannot be abridged. 5 judges said Parliament is supreme. Justice Subbarao tilted the balance in favor of the Constitution, in a sense. And he said fundamental rights cannot be abridged. Ultimately, the majority was the view expressed by Subbarao. The famous thing about Justice Subbarao is that he was a famous or notorious dissenting judge. 90% of the cases he dissented, whether as a judge or as a Chief Justice. I'm not sure whether the same thing was in Andhra Pradesh, when he was the judge of the Andhra Pradesh, when he was the Chief Justice of Andhra Pradesh. But as a Supreme Court judge, in many cases, he dissented. He was a great judge in the sense, most of the views expressed by him, which were dissenting notes, later became law. That in the sense, the Supreme Court later approved those views. But so far as Kesavananda Bharati, Golakanath is concerned, again the wave tilted. Subbarao, the majority judge, majority view propounder, held that fundamental rights cannot be abridged. Then Kesavananda Bharati came. Lot of controversy went in Kesavananda Bharati case. If my recollection is correct, it was argued for 68 days. One of the authors have mentioned that it would have been argued for much more time. On 23rd March 1973, arguments concluded. That too because Justice Sikri was retiring a month thereafter. And he was one of the judges. Sikri cautioned them, if you do not complete the arguments, it is not possible for us to read and deliver the judgment. I'm going to read the record, arrive at a conclusion and deliver the judgment. If you do not do that, again, freshly the case has to be heard by a bench. Then the advocates completed the arguments on 68th day. Then on 24th April, the judgment was delivered. There were several parameters. Apart from the basic structure, theory, there were several parameters in this curious judgment. Curious in the sense. Generally, when 2 judges or 3 judges write a judgment, if 2 views are taken, let us say, 2 judges take one view and a single judge takes a different view. First, the majority judge reads the judgment. Then minority view judge reads his judgment. The minority view judge signs his judgment. The majority view judges, both the judges sign the judgment. Who wrote the judgment signs first, the other judge signs later. There were also cases I faced in one situation when a case was argued. I was a junior of the 2 judges. A case was argued. My learned senior posed about 3 or 4 questions. The advocate answered. That case went on arguments for 4 days. After half an hour, I posed 3 or 4 questions. The moment I completed the questions and answers came out, my senior judge turned around and told me, Shankar, you write your judgment, I will write my judgment. I said, okay, sir. Then first he wrote his judgment. He sent it. Diagonally, that was my opposite view. Then I wrote my judgment. Both the judgments, when we take it, he was a senior because they are equally divided judgment, 2 judges case. He read his judgment. Then I read my judgment. Then in the state courts, that's high courts, the case goes to a 3rd judge. The 3rd judge gives a finding that is final. He cannot give a judgment other than the view taken by either of the judges. In the Supreme Court, the situation is slightly different. If 2 judges, in most of the cases, 2 judges sit in Supreme Court also. If the 2 judges sit and give 2 different opinions, a 3 judges bench would become it's not that the matter goes to a 3rd judge. A 3 judges bench would be constituted, the matter would be heard, and the three, as I understand, are none of the two judges who have delivered the judgment. Then they deliver, they take a view and deliver the judgment. In Kesavananda Bharati, again, in Golakanath, it is 6-5. Then, as far as I understand, the total strength of the Supreme Court at that point of time was 11. All the 11 judges sat and heard the case. When Kesavananda Bharati case came up, there were 13 judges in the Supreme Court. All the 13 judges sat and heard the arguments. In those days, I was a student when the case was argued before the judges, and it was being reported daily in Hindu or Indian Express. I still remember, on one day, I think Justice Matthew asked Falkiwala, Mr. Falkiwala, if you are not insisting that 24th Amendment is not violative of is ultra vires, then I will consider accepting your claim. Then Falkiwala retorted, Milord, for the last 4 days, I have been arguing that 24th Amendment is ultra vires. And now you are asking me to concede it. How can I concede? Then the judge kept quiet. Ultimately, the case was decided. Almost like in Golakanath case, here also Justice Sikri tilted the balance. But for Sikri, the 6 judges each. And Sikri said that fundamental rights can be amended, but basic structure cannot be changed. This is the view that was taken. Funnily, very recently, the great Vice President, who was a senior advocate, if my understanding is correct, has pointed out at Bhopal in the Judicial Academy that Parliament is supreme. It can make any law. Who can question? How can the court question any law that is made by the Parliament? Perhaps the answer is Constitution is supreme, not the Parliament. Therefore, any law that is made, assuming by Parliament, in violation of the Constitution is to be struck down. And the Supreme Court is the guardian and the protector of, not Parliament, of the Constitution. Therefore, I believe that the Supreme Court is certainly entitled to put its foot down when any enactment is made by the Parliament or any other state legislation in violation of the Constitution. But again, curiously, one of the arguments raised by Falkiwala about Falkiwala, he was basically a tax lawyer. There is a famous book, still I think, the 4-volumed or 5-volumed Kanga and Falkiwala, that famous income tax text is there. Advocate's edition, 4 volumes or 5 volumes. That's a very famous book. And Falkiwala was known to be a good or an expert in tax laws. But in Golakanath, for the first time, Falkiwala earned the name that he was a constitutional lawyer also. And after Kesavananda Bharati, he has been more recognized as a constitutional lawyer rather than a tax expert, tax legal expert. Falkiwala submitted to the court that Parliament is not supreme, the people are supreme, as we the people of India, as the preamble says. Therefore, Parliament cannot make any law abridging the fundamental rights. I had with great respect to Falkiwala, I did not understand what he was saying. But does he mean to say that whenever a law is to be made by Parliament, particularly a constitutional amendment, a referendum is to be made, and then the people should decide whether the law is to be accepted or not, the amendment is to be accepted or not? I do not know. Perhaps that is what the intention of Mr. Falkiwala. But ultimately, I agree with the Supreme Court. Of course, you may say that who are you to agree? But at least intellectually, I accept the view of the Supreme Court that the Parliament cannot make any law violating the basic structure of the Constitution. There again, the Supreme Court had problems. Some laws are made, certain amendments were made. Some of the amendments were for the benefit of the people. Patently, they appear to be for the benefit of the people. Like at the time of the first amendment to the Constitution, one of the questions was, one of the aspects that was questioned in Sankari Prasad Singh Dev was the abolition of zemindaris. Everybody, of course, none of us, I think, were born in the zemindari era. We do not know what a zemindari system is. I used to hear tales about zemindaris, and I read several novels and several stories how cruelly the zemindars were, and somehow noble a few zemindars were. But when that step was taken, the Supreme Court did not agree at that point of time. No, you can't do it. That is a violation of a fundamental right to property. Therefore, you cannot do it. Then Nehru invented the first schedule. Similarly, now at the time of the case of Ananda Bharati, 24th Amendment, 25th Amendment, 29th Amendment, they were all questioned. One of the dilemmas of the Supreme Court was whether some of the amendments were for the benefit of the people. Is it for us to strike down an amendment that is in favor of the people, or shall we uphold it? Technically, judges of the Supreme Court are not politicians. They have to hold anything in accordance with law. Then, according to law, shall we say that the fundamental rights cannot be abridged, therefore, we agree with what Golaknath has said. They thought other way around. Then they invented this basic structure theory. I think judges, when 13 judges heard the matter, they sit, they discuss the matter, and in the views in the chambers, they view two views generally two views emerge. One view is for one set of judges, another view is for another set of judges. Amongst the two sets, the senior-most judge would decide as to who should write the judgment. They call it opinion. Who should write the opinion? And that gentleman would be asked to write that judge would be asked to write the opinion. That gets circulated, and the other judges of the same view either add, subtract, or say, we will do that, we will do this, and all that. In our Supreme Court, the system is slightly different. Once Gajendra Gadkar has pointed out, when a 5-judges case was heard, where he was to write the judgment, he wrote the judgment, one of the judgments, and he circulated to another judge. Another judge wrote on a pencil by the side, delete this, add this, do that, do this. Gajendra Gadkar was terribly irritated. It seems he wrote back, I am not going to add a single word, and I am not going to delete a single word. If you are willing and acceptable, quite well and good. Otherwise, you write your own judgment. It is possible. It is possible in the sense, sometimes what happens is, a broad decision is taken. Generally, we accept that view. Once, when I was recently appointed as a judge of the High Court, Justice Ravindran, he retired by then from the Supreme Court. He told me, he gave an advice to me. When, brother, you are sitting with a senior judge and you both reach a conclusion, Then if the senior wants to write a judgment, let him write the judgment. Then I said, sir, if I want to write it, no. Give the choice to the senior judge. Let him write the judgment. But when you are differing with the senior judge, you have to write your own judgment, you will write. Even when you are agreeing with the senior judge, you read the judgment when it is circulated to you. On some points, occasionally it happens. On some points, you may not agree. If you do not agree, to that extent, you write a judgment, stating, I wholly agree with the finding of the view expressed by my learned senior brother. However, on these points, expressed at para so-and-so, I differ. With respect, I differ. This is my view. You can write that way. This is what happens generally in the high courts or in the Supreme Court when more than one judge sits. Of course, in the Supreme Court, the question of a single judge sitting doesn't arise. Then the 13 judges must have sat and discussed. And ultimately, most of the judges reached the conclusion that fundamental rights can be abridged. However, subject to the condition that the main frame of the Constitution shall not be amended, shall not be changed. Peculiarly, we all have great respect for Justice H.R. Khanna. He was the great dissenter in ADM Jabalpur, that is habeas corpus case, and which ultimately led to his being axed from becoming the Chief Justice of India. Very peculiarly, in his judgment in Kesavananda Bharati, Khanna said, fundamental rights are not basic structure of the Constitution. They can be amended. In other words, they can be abridged. However, an underlying basic structure is there. That basic structure should not be disturbed. Take the case of habeas corpus. In that, Khanna said, Article 21 it's also part of the fundamental rights, isn't it? Article 21 is a basic structure of the Constitution that can never be amended, whether the emergency exists or not, whether the other fundamental rights get suspended or not. Of course, later another amendment was made that Article 32, that's right to go to the Supreme Court, also cannot be taken away even during emergency, etc. I do not know why Khanna has shifted his stand from Kesavananda Bharati when it came to the habeas corpus case. Of course, what Khanna said is absolutely appreciable, and that is what the present law is. That is, that's what the learned judge of the Supreme Court has pointed out. He referred to as Maneka Gandhi, that was known as Maneka Gandhi in those days. Later, Maneka Gandhi said, I am Maneka, I am not Maneka. But there was a lot of confusion. That judgment was referred to as Maneka Gandhi versus Union of India. In that, the Supreme Court took a different view and said that the habeas corpus case is not correct. One of the fundamental rights, that is right to life, cannot be disturbed. Again, the Supreme Court, that one of the sessions, it will come as a judicial activism. Some people heckled it as judicial over-activism. Whatever way you call it, that Volga, in Volga case, for the first time I think, later subsequently there were several nations where the Supreme Court said right to life means right to live in dignity, and therefore went on expanding Article 21 of the Constitution. They called it basic structure of the Constitution. But when initially, when Kesavananda Bharati judgment was delivered, funnily, most of the judges gave a list of matters, a negative list. These are not the basic structures of the Constitution. Right to property, I think most of the judges said, right to property is not a basic structure of the Constitution. Then another aspect where I feel highly irksome is about the way the Kesavananda Bharati judgment was pronounced. Two things happened. First, because there were 13 judges and they took different views, what is the ratio of the Supreme Court ultimately is a question that arises for consideration. I still remember the book written by Professor Lakshminath Garu on law of precedents. Ratio and arbiter were thoroughly discussed in that book. Most of you are aware of what is a ratio and what is an arbiter. When the question is to be answered, Justice Sikri, the then Chief Justice, invented a method. He said, this is the ratio. Then, when he wrote the ratio, 5 or 6 judges, I think 5 judges, 4 of them undoubtedly they were not in favor of that Parliament is restricted by the basic structure of the Constitution. However, some of the judges held that basic structure cannot be violated by the Parliament. That is the majority view. In spite of that, the dissenting judges actually are, it looks very curious. The first of the dissenting judges is A.N. Ray, who was immediately benefited with the Chief Justiceship. The moment Sikri, I think my recollection is correct, Sikri retired a couple of days after Kesavananda Bharati judgment was pronounced. Then generally what happens is, when a Chief Justice is to retire, generally, many times, the President asks the Chief Justice who shall succeed him. And obviously, the outgoing Chief Justice names the next senior most man. Apparently, Sikri was also asked that way, and Sikri suggested the name of Shellett. However, Shellett, Hegde and Govar, who were seniors in the order, were superseded by Indira Gandhi, and A.N. Ray was made the Chief Justice. Next morning, A.N. Ray took oath, and he said, I do not know that I will be considered as Chief Justice. I was never aware. In the morning at about 8 o'clock, word was sent to me to come to the President. I went to the President, and the President told me that you are to be sworn in as the Chief Justice of India, and then I took oath. I do not know whether when the President called him, he went with his robes, or just he went in a slack shirt, because the swearing in is with robes. I do not know, but that is what Ray said. That is, he is first of the 5 judges who dissented. Another judge was also subsequently benefited or given the blessings of Indira Gandhi, that is Beg. After A.N. Ray retired, Khanna should have been the Chief Justice. Then the senior most judge was H.R. Khanna. Apart from the Kesavananda Bharati, in that habeas corpus case, Khanna dissented. The remaining 4 judges said that even during emergency, even if a person is killed by government, nobody can question. That was the view they have taken. I think that was written by the earlier Chandrachud, the father of the recently retired Chief Justice. Then Chandrachud, of course, subsequently said, I am ashamed of the judgment and all that. But the judgment existed where the Supreme Court said that during emergency, even if a person is killed, nobody can question it. Khanna said nothing doing. No, it is not possible. Article 21 always is saved. Therefore, right to life is always protected. Therefore, he was in the dissenting note, and he was not appreciated by the then Prime Minister. And when they turned, A.N. Ray retired, then immediately Khanna was superseded, and Beg became the next in the most man was Beg. Beg had 2 choices, 2 opportunities. One, we are making a Muslim a Chief Justice. Secondly, we are taking revenge against Khanna for writing such a judgment. Both ways, that was beneficial, and he was made. But thereafter, never there were any supersessions in our Supreme Court. First, at the very first, when Kania retired, just Jawaharlal Nehru wanted to bring Setilwad as the Chief Justice of India. He was the Attorney General. So I am not sure whether Setilwad was informed. Thank you. I was asked to conclude. I will conclude. Give me a couple of minutes. Setilwad said that I do not know whether Setilwad was consulted, but ultimately, when the judges, remaining judges, told Jawaharlal Nehru that if you are going to bring any man other than the next senior-most man as the Chief Justice, we are going to resign en masse. Then Nehru was afraid, and he allowed Shastri to become the Chief Justice. Then I will not go further because, as it was pointed out, a slip was given to me that others would speak. I will point out only one thing. I rate this judgment of Kesavananda Bharati as a novel for young judicial officers, how a judgment should not be written. This is 101 page. But there is another case, equally good case, that is T.A. Pai's case. I was law secretary. There was one additional advocate general. There was an advocate general. The chief minister mischievously asked three of us to give individual opinion what T.A. Pai said. I gave one opinion. This is what the ratio of T.A. Pai. The additional advocate general gave one ratio, and the advocate general gave one ratio. All of us were honest. None of us coincided. That was a wonderful judgment. And again, the same thing with Kesavananda Bharati. The judgment, 101 pages. Sikri wrote 101 pages. And then Khanna wrote 99 pages. I think that is not the way a judgment is. No, certainly there are issues that are to be dealt with, but that is not the way a judgment should be written. There are other things, other advocate, the two young friends are there, and apart from that, Lakshminath Garu is there. Therefore, I will not take time. But I thought that I am allowed 20 minutes or 25 minutes. But anyway, I am concluding. Anyway, that's enough. That's enough. I will not go further. But already clapping to asking me to go and sit down. I am sitting. Thank you.
Yeah, good afternoon, everyone. I'm neither a professor nor I'm a judge. But since I'm part of the panel, I would just say I concur, since I'm the junior in the panel. So if I was part of the Kesavananda Bharati and if I would have been one of the people writing the judgment, I would only have said I concur or I dissent. Possibly that's the shortest opinion one can have on Kesavananda Bharati. But as a lawyer who's put in about 17 years of practice and I'm part of this alma mater, I'll just point out few things as to how the legal profession functions and what exactly we as legal professionals see a particular judgment or a particular provision as. Now, when we say basic structure, what is basic structure? If we actually see from a civil contractor's point of view, it will be something where the entire superstructure stands on. Now, when we say basic structure, do we mean that it is that structure on a constitution stands? Or is it the structure on where the entire legal fraternity or the legal system stands? Or is it we as members of the legal fraternity being completely scared of the legislature and the executive, which continuously tries to threaten the independence of the judiciary? Is that what we fall back upon? Is what is called the basic structure. I think everyone can have a different view on basic structure. But I think from my point of view, basic structure is that basic minimum level of defense we as legal professionals, when we say professionals, be it lawyers, be it judges, be it any people looking at the saviors of the Constitution, saviors of the rights of the people, that's what we fall back upon is called the basic structure. And if you actually see, basic structure is also an argument of convenience. It is just an answer to an existing social structure, an existing political structure. If we had to argue basic structure today and not in 1970s, we'd have to understand the background of where the basic structure doctrine came from. It was a prelude and something which was a counter-jerk reaction to the emergency era. Would we, as the holders of the Constitution, still do the same thing what was said in Keshwananda Bharati today? The answer would be an emphatic no. Every jurisprudence which actually evolves is an outcome of its circumstances. Basic structure for me actually goes back to the American Constitution, the 14th Amendment, Brown versus Board of Education, where the 14th Amendment was being interpreted and it was equal, separate but not equal. You would have separate schools for Browns and separate schools for whites. There, the interpretation of the 14th Amendment was completely different, and again, it was the churning of times in America. Now, is basic structure what we see today is what Nani Palkiwala argued in Keshwananda Bharati? Answer is no. Basic structure actually came, one of the propounders was Professor Dietrich, the German scholar. He, during the Hitler era, if you're aware of what Hitler did, he brought the Enabling Act. What was the Enabling Act? One of the most ruthless pieces of legislation, which said that no procedure has to be followed by the legislature, and it can overrule and can run through the Constitution, overrule the Constitution, and the Enabling Act can do whatever without following any procedure in the Constitution. Now, this was contradicted by Professor Dietrich, saying that there are doctrine of inherent limitations. This prophecy of inherent limitations later on became the basic structure which was incorporated by the series of judgments which my predecessor speaker and the Honorable Judge spoke about. But do we see the basic structure as what we see it today? A couple of anecdotes regarding how the basic structure came into being. And that brings me to Keshwananda Bharati too. Very few people know it because this is not what has been reported. After Keshwananda Bharati, there came the emergency era, where Indira Gandhi versus Raj Narayan came into picture, the 39th Amendment. Then the 41st Amendment was being brought into force, because obviously at that particular point of time, the Supreme Court was looking into the validity of the election of Prime Minister Indira Gandhi. At that particular point of time, Justice Ray constituted a 13-bench bench to reconsider Keshwananda Bharati. Now everyone was flabbergasted, who has constituted the bench? Why Keshwananda Bharati too? And while it was being argued, and Nani Palkiwala argued for a day, the very next day, in fact he argued for a couple of days, I apologize. The third day, a question came, who constituted the bench? Palkiwala said, sir, I did not. Why would I? There is a judgment in my favor. He very cunningly looked towards the Advocate General from Tamil Nadu. And he stood up and said that I did not request for it. Then he looked at the Advocate General from Gujarat. Did you? He said, I did not. And then everyone looked at Justice Ray. And the entire courtroom knew that it was Justice Ray who wanted to constitute it. And it was Justice Ray who wanted to review the judgment of Keshwananda Bharati. So the cat was out of the bag. The Chief Justice was exposed in front of the entire courtroom. The very next day at 10:30, when the 13 judges assembled again, the only thing Justice Ray said was, I dissolved the bench. This is what people who have courage do. This is what Nani Palkiwala stood for. And this is what Nani Palkiwala has given us. without saying a word, creating circumstances and actually making the Chief Justice dissolve the bench is what Nani Palkhiwala stood for. There's another anecdote of Keshavananda Bharati I'll share with you. I was just sharing with a few of my professors just before this. Nani Palkhiwala was being completely bulldozed in the first day of Keshavananda Bharati. Was not allowed to speak. He was arguing before 13 judges, and out came 13 judges firing him left, right, and center, not letting him speak. Questions after questions after questions. I have to salute that man, that we appear before single judges and division bench judges, and they don't allow us to speak. And we piss in our pants. And he was there, right, a sole warrior, dealing with 13 Supreme Court judges all by himself for the entire day. But after the day, while he was retiring to his room, he spoke to Chandu Daftari. He was very lovingly called Chandu Daftari, C.K. Daftari. He said, Chandu, I'm not going to argue tomorrow. I've had enough of this. I think the judges are opinionated. They already know what they want to do. It's a political gimmick. I know that they are not going to hold this in the favor of the Constitution. C.K. Daftari said, what do you want? You want to fight or you want to just surrender? I want to fight, but do I fight with these judges who don't allow me to speak? Chandu Daftari said, you would have a very quiet audience tomorrow morning. So he was completely surprised. How would this happen? He sent one of his juniors to Justice Ray's chamber and said that Mr. Daftari wants to speak to you. And Daftari had a tremendous respect in the entire community. Even the Chief Justice would give an ear to him. He went to his chamber and he congratulated him regarding the entire bench and how the working of the hearing was taking place. And then he said, I'm here just to tell you a story. He said, what's the story? That I was in the court chambers and this beautiful small girl came with her father. And she was completely appreciative and enamored by the Supreme Court and how beautiful the building is and how beautiful everything is and how everyone is so sophisticated and how beautifully the lawyers speak. But who are those croonies sitting there interjecting all the time and not allowing these lawyers to speak who are so eloquent? My lord, that is all what I wanted to convey. And this is the story I wanted to tell about a small girl. Justice Ray could say anything. He just said, thank you. The next morning, none of the judges spoke. Mr. Palkhiwala got an audience from 10:30 to 4:30 and he weaved his magic. He weaved his magic not only in context of what the basic structure was, but he spoke about what we stood for, what was the spirit of the Constitution, what we as the society stand for, what we as lawyers and judges have to defend the separation of power, how we have to defend every aspect, the spirit of the Constitution. Everything he spoke about, only and only because they were people with courage who could call a spade a spade. So I think people like Daftari, people like Nani Palkhiwala, people like H.M. Sirvai, very few people know H.M. Sirvai, who was actually in a majority of these cases opposing, and he was defending the state, was opposing basic structure. You start from Shankari Prasad Deo, you then go to Golaknath, you go to all these judgments. But one thing you'll find, and you'll find the beauty of this is Sirvai wrote 3 volumes on Constitution. But never in one line did he actually come up with his opinion on what he argued from the state. That is a true piece of scholarship. Because these were the people who actually deep down knew, irrespective of whether they were arguing for the state or they were arguing for a private citizen, they knew what upholding the Constitution was all about. And that is what we lack today. We as students, and when I'm addressing the students today, what we see, and I want to convey it to all of you, is that I see commerce everywhere. I was just speaking that I don't say a word if I'm not paid for it. I'm a lawyer. Today we are not talking about the principles, we are not talking about what the Constitution stands for. All these are very boring concepts for all of us. The newer generation is all about, oh, this is a very age-old concept. Don't tell me all this. It's all about commerce. It's all about arbitration. Very few people, I was just speaking to one of my fellow panelists, that in court, we don't even refer to the Constitution. We don't bring the Constitution, the book. We bring the CPC, the CRPC, the IPC, now all those enactments, the Arbitration Act, the Commercial Courts Act, the Companies Act. Nobody cares about the Constitution. Everyone presumes that they know the Constitution, but nobody actually wants to implement the provisions of the Constitution. Nobody knows what the directive principles of the state policy are. Now, this is very interesting tug of war. We talk about the basic structure of the Constitution. The question here was, and that's what was being discussed earlier, what comes first? Fundamental duties or fundamental rights? Unfortunately, in the Constitution, first came the fundamental rights and then came the fundamental duties, whereas it's the other way around. You want fundamental rights, first you do your duties, then ask for your rights. Unfortunately, even the fundamental duties, whether they are implementable, whether it is something where somebody can go to the court and say that I want to enforce the fundamental duties. Everyone is talking about fundamental rights. Article 226, every day we come up to the court and say, so my fundamental right or my legal right is violated. How many come up and say that it is my fundamental duty, I want to implement it? All these now are part of the basic structure of the Constitution. So all I want to say on this, I had at least 70, 80 pages on various judgments, but I thought that this is mugging up and puking it out on what a particular judgment says. But I think today, apart from what the political structure is, apart from what we individually think and what our point of view is, we need to independently gauge as to what we see as the basic structure of the Constitution. If we, as guardians of the Constitution or the keepers of the Constitution, don't see that as a document which completely keeps changing with time, I think we'll be missing out on many other things which we need to see. Thank you so much.
Good afternoon, everyone. I am actually honored to be a part of a panel where Honorable Justice K.G. Shankar is the chair, and co-chair Professor A. Lakshminath, who we are yet to hear and looking forward to. I am equally looking forward to hearing him like all of you. And I am very proud of sharing the panel with Sankalp co-chair, who is a fellow alumni like me. And again, it's an honor to be speaking in front of the teachers, VC, who actually we have all the teachers who taught us and other faculty members who, I didn't have the good fortune of being with them because I graduated in the year 2004. Happy to be speaking particularly to those who had the bad fortune of teaching me because I'm sure I was a lot of trouble back then. But having said that, it is actually, I'm very, very happy to be here and speaking about a topic on which before I actually speak, I'll have a lot of disclaimers because you all may know that I was part of a law firm where the first training is that before you give an opinion to a client, you must give the qualifications and disclaimers. Therefore, it is very important to first give the qualifications and disclaimers. First, qualification is that, as Sankalp rightly pointed out, as a matter of fact, not stating it proudly, but as a matter of fact that we barely refer to the Constitution in our practice area. My practice mostly is focused on corporate commercial laws, and unfortunately, Constitution is not something that we teach day in and day out. Second qualification is that I am filling in for a colleague, so I was not supposed to be a part of this panel. So that's the second qualification. And having said that, I think the topic that is before us is more of a general topic for most of the students of law. And we heard very interesting history, views, and anecdotes about the basic structure of the Constitution and the judgments that are the key judgments insofar as this issue is concerned. I would restrict myself to the issue, because today there is also a discussion and debate about whether this whole concept of the fact that whether Supreme Court or the High Courts are someone that can question any law that has been passed by the Parliament with majority, and whether this concept of basic structure or constitutional morality, etc., that are being evolved, are the right thing to do. The answer to that is actually, a simple answer is, I think yes, it is the right thing to do. But having said that, we need to bear certain things in mind. Whenever we try preserving any concept or jurisprudence, we need to be mindful of a few things, which is that ultimately any society or any document like the Constitution, the idea is to protect the people. There may be times when we may not be happy with the Parliament or the politicians or the executive. There may be times where we may not be very happy with the judges that are sitting in the Supreme Court or the High Courts. But the concepts that have been involved, one will always be influenced, the law or the concept that are evolved by the judges or the courts will always be influenced by the keepers or the parliamentarians or the Supreme Court judges. It will definitely be evolved by them. Now, at times they may rightly reflect the needs of the society, at times it may not rightly reflect the needs of the society. Having said that, what is most important for us to bear in mind is that in a given situation, as I pointed out earlier, that we may like the political regime, we may not like. We may like the judges, we may not like the judges. But I think any institution, if their powers are left unchecked, then it is a problem for the society as a whole. Therefore, this concept of basic structure, of course, what exactly is basic structure is every judge in the evolving times, rightly, wrongly, or maybe differently from the previous times, will interpret it in a manner that suits perhaps the need of that time. Similarly, the Parliament may enact laws which may suit the times or suit the present regime. Like one simple example, and Sankalp mentioned about it, is, for example, the judgment of Indira Gandhi versus Raj Narayan. Now, I am not on the right or wrong of that. The certain provisions of the Representation of People's Act were amended. Article 329 of the Constitution was amended, which actually enabled that any office bearer, so for example, the Prime Minister's elections cannot be a subject matter of judicial review. The question is that is this the right thing to do or the wrong thing to do? According to me, Parliament in its wisdom enacted this law or amended the article and the provisions of the relevant statute. Should this not be subject to judicial review? The answer to this has to be a clear yes, that it has to be a subject to judicial review, because otherwise any power that goes unchecked will become a problem for the society at large. Therefore, I am a votary of the fact that the basic structure, the concept has been rightly developed. Of course, it will keep changing with times. It is, I mean, we are all evolving. We are all learning new things. Our society is changing. We are all learning new things. Therefore, the short point is that I am a votary of the fact that the concept that the basic structure of the Constitution needs to be protected is something that I would support that. And I feel that our judiciary took the right direction by evolving this concept, and later it has actually been continuing to support it. One last point, particularly for the younger lords, we are living in a time when we find it very, very hard to read those longish judgments, Keshwanand Bharati being the basic judgment on this point. It is not actually a judgment, I would say that it's actually a book. So my suggestion is that if whoever is interested, there is a recent judgment on the right to private property judgment. If some of you are interested, I think it's a very shorter judgment. it actually brings out the history of this very, very well. I would suggest that because it's a shorter one must read it to begin with, and if it interests you further, then you can go back to the longish judgments of the past. With that, as I pointed out earlier, that we are looking forward to hearing Professor Lakshminath, and I will give the floor to him. Thank you, and honored and a pleasure to be speaking here.
Esteemed Chairman, Honorable Justice Shankarji, my two young friends, I'm extremely thankful to you for having given a very exhaustive account of the basic structure doctrine. And unfortunately or fortunately, you have not left anything for me to speak on this. Anyway, friends, I'm extremely thankful to you for lending me your ears, despite the fact that the lunch is awaiting you. I am extremely thankful to Honorable Vice Chancellor, today the chief host, who started with Yato Dharmas Tato Jaya, and then he ended with the chief guest saying that no, we have to initiate, or else we have to introduce nostalgic is our ancient Indian, or what should we say, dharma of prudence, instead of calling jurisprudence. So here, I do not want to go into the legalities of this one. Let us have some socio-legal aspects of it. Basic structure doctrine was criticized on several counts, and particularly during 1970s, it was considered as it is not a legitimate one. It is legally not legitimate, morally not legitimate, socially not legitimate. These are the main criticisms. And thereafter, there are very great jurists also criticized. It is not that Fukuhama, who has said about the end of history, but it is the Supreme Court now which has written the end of history by saying this basic structure doctrine. Because basic structure doctrine, I think, Sikri, like Kahola or Kahoda, this is the end of it. Because he has given some 6 propositions in his brilliant analysis or judgment or what is his opinion. He wanted to sum up. He has given for the first time a summary. And this summary, some 4 people have refused to sign. And there he has made some 6 propositions. And the most important proposition was the second one, saying that the parliament is not enabled to alter the basic features or framework. Basic and framework. Basic structure or framework. Afterwards, I think several people have included several features. But this is the one. Out of 13 judges, there were 11 judgments. This is a historic one. Out of these, I think 11 judgments, 4 people have openly refused to sign. And out of the remaining, it was not even discussed. See, ultimately, the most important decisions with respect, with great respect to the justices, before, they retire as Chief Justice, they have a fascination to go abroad. Well, friends, this is a case which was a very important case which the court itself has made I think more than the court, it is Nani Palkiwala who made it very, very great. A humble, I think you see Shankari Prasad, this Keshavananda, he has not yet taken over the charge of a pontiff. Suddenly he was scared that Kerala Land Reforms Act is going to affect his property. So his friend is a very local lawyer. He contacted Dada Chandji. Sir, whether we can go to the court. So Dada Chandji consulted with Nani. And then both of them, they said, come on, let us go under Article 31. 31 by that time, as actually emasculated. In the meantime, somehow it has come to their mind, why not we go under Article 29? Because this is a question where is a question of taking over religious mud. And that is going to have more impact. In the meantime, the court also was packed by some yes judges with the help of Kumara Mangalam and others. The result was they have become more bold and they have brought in 24th, 25th and 29th and including 26th also. So having brought them, this is the where Palkiwala has made a greatest turning point in the history of the constitutional history itself. He said, why not we push it in the 29 with regard to the fundamental rights. That is how it has originated. Well, friends, seriously, if we go further backwards, right from 1950, because we have to take the political and social conditions also in the country. Right from 50 to 1964, we had a politically stable country, there was stability. 64 to 65, there was some political instability. After 1967, there was instability in politics. You must see, after the demise of Jawaharlal Nehru, there was, and thereafter, the states now have started to their own autonomy, and it is during this time there was absolute political instability. That is what made caucus bro constrained. But if this is the brutish majority, if this is going to be there, then what will happen? And this he has already taken the hint from Justice Madholkar's dissent, particularly in Sajjan Singh's case, where which Madholkar clearly said, there are certain fundamental things which cannot be changed. That only one sentence he has left it. But Justice Hidayatullah was more assertive, saying that our fundamental rights for which we have fought for so many years, are they so amenable to the ordinary legislative amendment of the parliament? I think these are the only two indications. But Subrao has lamented, because immediately after he resigned as a Chief Justice, he said, I did not have the academic strength to support or buttress my argument, so that in Golaknath he can use and he can say that already 17th Amendment he wanted to make invalidated, even retrospectively also. But then somehow he made it by making it prospective only. Well, friends, please remember 67 to 73, how the things have changed. In between, Bangladesh was born. And authoritarian politics have come. And this is the period, then judiciary was very much vigilant. It has to legally take and exercise the political power. But at the same time, it does not have the political responsibility. How to coincide with this? At this time, Palkiwala with Dada Chandji, they have brought this political instability. Then you see, like, what do you call it? Kahola. You know, perhaps I want to say, because this, I am inspired by our Vice Chancellor and also Justice Mittal also. Kahola was the son-in-law of Buddhalaka. Buddhalaka was a very great and very learned saint, and his daughter's name was Sujata. So he wanted to find out a great intellectual Sishya, and he found in Kahoda or Kahola. and he got his daughter married to Kohola. And Kohola also was a great person who was learned. And suddenly he found his own son to be wiser than himself. Therefore, he has cursed him. Then came Ashtavakra. So Ashtavakra was the greatest intellectual one, and I may be wrong. Krishna taught Gita to Arjuna, and it is more or less no Dvaita. But I may not be correct also. Ashtavakra discussed with Krishna about Gita, about Advaita, or some people said Avsishtadvaita. So when you take this topic, I thought that Supreme Court and basic structure, are they two different things? What I say is basic structure. Whatever you may say may not be. They are one and the same thing. Aham tamevaha tameva aham. This is. So, I mean, he has produced a very good son. Like that, Sikri, he went abroad. 24th, he has to deliver the judgment. And 25th April, he has to retire. And by the time the court is packed with so many people, see, no or yes, yes or no people. He had as a difficult task. He should have come a week before. He landed on 23rd. He said, why we have to finalize the decision. And he called some people, only 4 or 5 people. And then said, you please write something. See, this is how he has not consulted. And he has given rise to a basic structure doctrine like Ashtavakra. All wrongs. Absolutely so many deformities. He could not articulate this. And that is how, why see some people call it is creative. Creative judicial arbitrariness. How can it be? Arbitrary. I said it's basic structure, basic framework, without telling what it is. And they themselves have confessed. And they all said, I think it's on 10th and 11th of November 1975, remember. These were the days of emergency, those days. And you know how the drama took place, Lordship? People were called. I think it was at that time, A.N. Ray was the Chief Justice. So he called on 10th all the people because they wanted to review his Keshavananda Bharati. 10th, the arguments went on. He saw all the people. No judge was in favor. All the 13 judges, they were not in favor at all. And 11th, again he went on. And no judges even replied. And there was so much murmuring. We never signed this. We never wanted this. Well, friends, the fundamental principle, there is a ratio decidendi. Where is the ratio decidendi here? It was not even discussed. It was not even in point. It was not even argued. What all Politikiwala wanted is 31-2 only. Not your fundamentalized, not your basic structure doctrine. And what was the order? No order at all. Order accordingly. 26th Amendment, it may be placed before the proper bench. What about 23rd Amendment? What about 24th Amendment? What about 25th Amendment? What about 29th Amendment? All three were held valid. This is the genesis of Ashtavakra. And then came Hora, great Sikri Saab. And then 25th he handed over the chair to Ajit Nath Ray. And Ajit Nath Ray, on 12th November 1975, it was such an awkward situation, I tell you. It is said to say, Mela Dhruva. Awkward situation for any Chief Justice of India and for anybody. The bench is dissolved. For what? Bench is dissolved. This man, the matter was argued for 5 months and 70 days. And for all this again, 2 days again, you have brought this one. And everybody has got to see his own conjectures. I told so and so. In fact, Palkiwala himself said he was on his he was not well. He said, I told Indira Gandhi, my dear Indira ji, please don't go ahead with this one. You please withdraw. बाद में पता चला कि he did not write. And his own Chela told, Andi Arjuna. And my own interaction with Justice Krishna Iyer. Krishna Iyer personally told me, he himself and Justice Bhagavati, they were very close, and they went to Madam Indira Gandhi. They said, Madam, please withdraw, because one day this may also help you. And that literally helped her. See, but of course some people have, because so many people have made so many decisions, because most of the people died. So this is how, during those days, particularly 73, I think April 24th, the decision was given. And people, were not able to apply this, because the very people who said no, they have to apply it. And they were not in a hurry about, you were talking about the 9th Amendment. That 9th Amendment, it was subsequently. But when the conditional stay was given then, and again when this has come, the appeal was allowed without applying the basic structure rule. And the review petition, this is what has happened. And the result is, what is the, actually, what we call the basic structure doctrine? What is the validity of this one? So, literally, those people have read this American constitutional law. When Chief Justice Marshall has laid down the judicial review, he never knew that this is going to be so important. Had he been alive, he would have wondered, what is this? I never imagined even this one. So like this, had Sikri, Senior Sikri had been alive, he would have been wondering, even this is being discussed in Bhopal today. See, such was this one. Then immediately they couldn't even apply for this one. They had to apply. That is how, what has happened is what we call fiat justitia. Fiat justitia and salus populi. These are the two things which are coming right from the beginning. Come whatever may, let heavens fall, we will do justice. That is literal legis. Salus populi, no, you cannot. Because people's welfare is more important. That is how basic structure doctrine survived. No doubt, in some cases, they could not even properly apply, they could not even properly articulate. Ultimately, Justice Salmeshwar also was pained to say you are using it for yourself, not for individual freedoms. When you say basic framework, or when you say basic structure, it's a collectivity of all the fundamental rights, but not your independence alone. That is what they have done in NJAC. You should have decided in a different way, but this is not the way. See, that's why these sort of things that Suprio, you must have read the case. See, there was a healthy tradition established. The judges, they do. Chief Justice Chandrachud, who was in minority, who was dissenting. Dissenting judgment was 120 pages. And the majority judgment was only 60 pages. There is Justice Bhatt and Justice Chandrachud. They exchanged their views. They tried to come to some consensus, and that is how they made it. But in Keshavananda, this has not happened. They were not seeing face to face. And during that time, one or two appointees of Indira Gandhi, Justice Dwivedi, who openly he wrote the judgment. When Justice B.D. Jetty, who was acting as president, he went and gave his wedding card for his daughter's marriage. This man, came to influence me. Friends, this is how the people have gone. That is where we can see under such circumstances it was born. But today it is our duty, because we are concerned with whatever may happen. Today morning we discussed, that is one thing in the minds, that in the psyche of Indians, Chatrasya Kshatraha et Dharmaha. I think there is no more basic structure than this. Kshatrasya kshatraha yad dharma. Law is the law is the king of laws. Law is the king of kings. Because the first and fundamental duty of a Raja is to obey. And that is Praja hitena hitasya rajyaha. Praja sukhena sukhasya rajya. This is salus populi. And that is how you see, where you have to see that all this doctrine should be applied. And this is very social power, social force. And these are all, see, ascriptional majorities and minorities that are going on. These are all ascribed. And this majority, see, tomorrow it becomes minority. But what is that remains is salus populi, the health of the community, social power, social force. It should guide, and this should speak through the court. That is what we call demosprudence, not jurisprudence. The people's voice reflected to the institution of the judiciary, where it is substantialism and institutionalism. For any function, for any principle, for any, even for this, the supremacy, the substantial provision is Parliament is supreme, because Parliament can amend under Article 368. This is substance. But then who is the protector? Supreme Court is the protector. That is a check. Check and balance, that has been there right from Kautilya's time, not this time. We don't need any constitution, because constitutionalism is in our blood. See all our neighboring countries, do they have a constitution? Do they have any respect for the courts? But we do have. In fact, we do have, despite all the so many things, I don't want to say this, that is the Indian psyche. That's what I want to emphasize. Therefore, friends, I think with this view. So now, the substantial portion where you see, there is always no Parliament is supreme. Parliament can amend. But Supreme Court also is the guardian, is the sentinel on qui. That is the role which Supreme Court sees. And secondly, institutional. Institutional are there. Checks and balances. That means internal checks are there. Internal checks, that is Article 13, Article 226, Article 32. And external limitations are fundamental. But as you have 326 is one of the most important things which nobody has included in the basic structure or features. Well, friends, see how that great man, because we read more than newspapers, more about America than India. Trump, I cancel your visa, I cancel your green card, I cancel citizenship. And you see, 326 amended, only those people who have got 60 and above will only vote. What will happen? Is it not a basic feature? Sir, Chairman, sir, thank you for giving this opportunity. Thank you all.
One word of conclusion. In conclusion, we have heard me, Lakshminath Garu, and our two advocates. Originally, I thought that after the session, if there are any questions that can be taken up, but there is no time. Therefore, I think we should conclude our session. Now, is there anything else? Then we are concluding our session. Thank you for patiently listening to us.
With this, we come to the end of the first panel discussion. We are extremely grateful to our esteemed panelists for sharing their invaluable insights. This was an immensely enlightening experience for all of us. I now request all the dignitaries to kindly proceed for lunch from the left side gate of the convention center, and all the participants to proceed to the right side gate of the convention center. The participants would be ushered by the SBA volunteers, so kindly remain seated. The dignitaries are requested to please proceed.
Hello. Good afternoon, everybody. I request everybody to please occupy the seats in front and please be seated. Thank you. I request everyone to kindly be seated. We will be commencing with the session now. Greetings to one and all present here. What an insightful day it has been. Next up, we have the panel discussion on the topic, Supreme Court and Digital Rights in the Information Age. The topic indeed is of high contemporary relevance. I request all the dignitaries for this session to step on the stage. We have amongst us Honorable Justice Shri R.M. Borde, former Judge, Bombay High Court, as the chair, Professor Shri K. Madhusudan Rao, Professor at Andhra University, as the co-chair, Professor Dr. Atul Kumar Pandey, Dean UG NLIU Bhopal, and Biswajit Dubey Sir, Additional Advocate General, State of Chhattisgarh, as the distinguished speakers. Thank you, respected sirs. NLIU Bhopal is beyond honored to be graced by your presence today. Now, I request the Honorable Vice Chancellor, Sir, Dr. S. Surya Prakash, to felicitate our esteemed guests. First, I request, Sir, to felicitate Honorable Justice Shri R.M. Borde. Next, I request, Sir, to present our token of warm regards to Professor Shri K. Madhusudan Rao. I also invite, Sir, to present our token of appreciation to Professor Dr. Atul Kumar Pandey. Thank you, sir. Last but not the least, I request, sir, to felicitate Biswajit Dubey, sir, our very own alum. Thank you, sir. Now, I must take a few moments to introduce all the dignitaries present on the dais. We are graced by the presence of Honorable Justice Shri R.M. Borde, former Judge, Bombay High Court, as the chair for the panel discussion today. His Lordship completed BA from Marathwada University and LLB from the ILS Law College, Pune, after which he was enrolled as an advocate in 1980. His Lordship started his career by joining the chamber of his father, a distinguished advocate practicing on the criminal side, late Shri Manohar Rao Borde at Bede. His Lordship then joined the chamber of Honorable Justice Shri A.B. Nayak as a junior on the establishment of the bench of Bombay High Court at Aurangabad, where he conducted various types of civil and criminal matters, as well as constitutional matters including service and cooperative cases. Sir represented Zilla Parishad, Municipal Council Bede, Municipal Council Kopargaon, and several other local bodies. His Lordship was a secretary of the Bar Association High Court Bench at Aurangabad during 1991 to 1992. During the span of his illustrious career, His Lordship also rendered services as part-time lecturer in MP Law College, Aurangabad, for a period of 2 years. His Lordship retired as a judge of the Honorable High Court of Bombay in 2019 and has been associated with MNLU Aurangabad since its very inception in the various capacities such as Chairman of Building Committee, Member of Planning Board, Executive Council and General Counsel of MNLU Aurangabad. Sir, I'm sure you are an inspiration to many sitting here. We thank you once again for taking out time to come down to campus today. Next, we have Professor Shri K. Madhusudan Rao, Professor at Andhra University, as the co-chair for the panel discussion. Sir is a senior faculty member at Andhra University's Department of Law. He has an experience spanning over 15 years as he began his career as a professor in the Department of Law, Andhra University, in 2009. Sir is also a holder of the Shri Peri Narayan Murthy Memorial Gold Medal, which he received in 2006. He is an esteemed member of professional bodies such as ILI and Institute of Constitutional and Parliamentary Studies. It is no doubt that Sir is known for his academic rigor and mentoring abilities, as he has guided numerous students and researchers in fields such as administrative law, constitutional studies, and human rights. Sir has also authored articles on rights of religious minorities, right to privacy, rights of arrested persons, etc., in various well-known law journals. Sir, it is our privilege to have you here today, and it shall be an honor to be able to hear your views today. Thank you. Next, we have our very own Professor Dr. Atul Kumar Pandey, Dean Undergraduate, NLIU Bhopal, as a distinguished speaker for the panel discussion. Dr. Atul is a professor of cyber law and chairperson of the Rajiv Gandhi National Cyber Law Center established by the Ministry of Education, Government of India at NLIU Bhopal. He is also the founding head of Department of Cyber Law at NLIU. Dr. Atul joined NLIU Bhopal in the year 2009, prior to which Sir was an assistant professor of law at National Law University, Jodhpur. He has designed and developed various academic programs such as Masters in Cyber Law and Information Security, PG Diploma in Cyber Law as Distance Learning, and PG Diploma in Cyber Law and Cyber Forensics. Sir has delivered more than 200 invited lectures in various programs organized by institutions of national repute such as NLUs, IITs, and NITs. He is also actively involved in the training of judges, police officers, and officers of the banks, and serves as the principal investigator for the project Online Capacity Building Program on Cyber Law, Cybercrime Investigation, and Digital Forensics. So his research areas broadly lie at the intersection of information technology and law, and he focuses on data privacy, cyberspace, digital forensics, electronic evidence, etc. Sir, we are honored to have you as the speaker today, and I'm sure the audience is looking forward to hearing your views on this topic that you understand so well. Last but not the least, we have Biswajit Dubey sir, Additional Advocate General, State of Chhattisgarh, and alumni NLIU Bhopal as the distinguished speaker. Sir completed his undergraduate studies from NLIU in the year 2004 and later became a partner at Cyril Amarchand Mangaldas from the years 2015 to 2023. Now, Sir has a flourishing independent practice along with his post as the AAG. Sir excels in areas such as insolvency, debt recovery, product liability, infrastructure, intellectual property, white-collar crimes, and so on. With over 19 years of experience in dispute resolution, Sir is also a Forbes-recognized top 100 individual lawyer and the recipient of the prestigious ASSOCHAM Bharat Legal Conclave National Legal Excellence Award for Dispute Resolution Lawyer of the Year 2023. Sir, we feel privileged to welcome you back on campus and are excited to have you on the panel. Without further ado, I request the Chair, Honorable Justice Shri R.M. Borde, to commence the panel discussion. Thank you.
distinguished members of the panel, Professor K. Madhusudan Rao, Professor at Andhra Pradesh University, Professor Atul Kumar Pandey, Dean, Undergraduate, NLIU Bhopal, Mr. Vishwajit Dubey, Additional Advocate General, State of Chhattisgarh, Honorable Justice Belur Mutt, former Chief Justice of Kerala High Court, Honorable Vice Chancellor of this university, Dr. Surya Prakash, Dr. Rao from Aurangabad, MP Law College, all distinguished academicians and dear students. I am aware that this is a post-lunch session. You must have the sumptuous lunch. And I know these are the natural limitations. I will take care of it. I will be taking, we have decided amongst us, I will take 5-10 minutes, and thereafter the distinguished speakers will speak on the subject. I will take less time because the thing is that now we are talking of the digital rights and the Supreme Court views on the digital rights. Probably I belong to a pre-digital era, and there is a transition from pre-digital era to post this present digital era. Same is the case with this country also. If you have the rural background, you will understand the things. We have seen the days when there was no electricity. We have seen the days when there was the invention of radio was considered to be with a surprise. Then there was any problem, we used to send the telegrams. That has become dead now. We don't know what is the telegram. Those offices are also closed. There were days when for making a call, telephone call to your dear ones, we had to go to the post office and connect a call to that place. Then that person used to be called. If you have the telephone at your residence, then you have to call the exchange. Exchange will give you the number, will give the connectivity. Then came the next change, probably in the technological area, and that's a major event, is during the sports event that took place in Delhi, Asiad event. Thereafter, the era of television came during Rajiv Gandhi's regime, and there was boost to the technological advancement and modernization. Then came these mobiles, probably in around 2000. There were pages before that. One doesn't know, but the future will tell as to the outcome of this invention of this mobile and these smartphones and what would be its impact. The scientists are speaking in different language regarding the future on the humanity and the use of mobile and all that. I will not go into that. So this is the way how the transition has taken place, and during last 20 years probably, there is a rapid technological transition. And I don't know whether we are in a position to catch the speed and keep the pace of these technological advancement. The same is probably happening with this digitalization and use of digital technology in all walks of our life. We have the digital payments, we have what not. Everything we express ourselves on social media, that's digitalization. The days have come, probably this generation, you just can't survive without the social media. To that extent we have gone. Whatever the knowledge we gain, probably most of, unless you are that much aware, there is a WhatsApp university where you get most of the knowledge. So there are pros and cons. When you speak of digital rights, in the common parlance, the rights under the Constitution are equally applicable to all the citizens. We say of Article 14, it's uniformly applicable to all. In the digital field, you speak of digital rights, then there is a distinction between digital haves and digital have-nots. It will apply to those who have access to the digital technology. When you talk of the digital rights, you may have to consider the issue of digital divide also, and what are the reasons of that. So far as the digital rights are concerned, Supreme Court has expressed something about it. Firstly, everybody knows about the Puttaswamy judgment. It speaks of privacy rights that have been recognized. Then freedom of expression on social media. Nowadays, you are finding the cases somebody posts something on the social media or puts his face or some expression as what you call status on the social media. That gives rise to some offense, and some police cases are filed. They say that the sentiments of the majority are offended. Such cases we are finding. Then somebody expresses, some comedian writes something, speaks something. He expresses something, maybe on social media. The police are after him. The constitutional issues have attained a different dimensions so far as the digital technology is concerned. Right is the same, but I don't know why we have become so impatient and so cruel sometimes while expressing ourselves on social media. So this has given a new dimension to the rights, the responsibilities. The distinguished speakers will shed light on this. Then there is another right is in respect of the access to internet technology. You must be aware that because of unrest in Manipur, for number of months, maybe for 180 days or something, this internet was banned. In Jammu and Kashmir, there is off and on, there is a disruption in internet. If you don't look here, because your businesses depend on internet, your education, whatnot, it has become a life and blood of the modern society. The Supreme Court has said that access to the internet is also fundamental in character. So far as the privacy is concerned, the digital privacy is concerned, in the recent judgment, Supreme Court has said, privacy is not the luxury of a few, but a foundational right for all unchecked surveillances, and that creates a chilling effect on the free speech and dissent. This is good so far as the right to free speech is concerned. This is good so far as the digital rights, digital freedom of expression is concerned. There sometimes in defense, the national security is raised as an issue, is raised as a defense. The Apex Court said that only raising an issue of national security that cannot override the constitutional freedom without due process. Can raise the issue of this national security, but at the same time, if you want to deprive somebody of his fundamental rights, you have to observe the due process of law. Now, so far as the banning internet is concerned, the Supreme Court has applied the proportionality test. There are 5 principles laid down. I may not go into the details. The other speakers will speak about it. The only issue which probably I think that probably is of some importance is regarding digital divide. The digital divide is something, a gap between the people who have access to the modern technology and those who do not have access to the modern technology. There are various types of digital divide. Those are maybe economic divide, sustainability divide, empowerment divide, and there are various reasons. There are limitations regarding the reasons may be where you are placed. So far as urban area is concerned, there is a lot of, there is a more access to the technology is more, maybe something around 64%. And so far as the rural area is concerned, there is always a disadvantage to the rural population where the access to the technology is less. Then there is a gender gap, women and men, that has also come up in the survey. So far as if 49% of the men have the access, then the women, that constitutes a group of about 25% only. Then there is an economic divide. On the basis of economics also, you are deprived of the high-end technology. That also deprives one's of the fundamental rights, which is a foundational right. Then the another thing is that I have said about the access to the technology. And the most important thing according to me is digital literacy is concerned. You may have access to the technology, but you must have the digital literacy also in order to gain the benefits. I think this would be probably the contours of the digital divide. What happens if you are deprived of the digital rights? Then you have the incapacity or disadvantages in the field of employment, education, and social participation. These are the issues probably one must have to consider while emphasizing on the constitutional rights or other rights having more with reference to the digital technology or digital. Now it is said that the government has taken forward-looking steps, and it is said that about 94% of the villages would be covered by at least one mobile tower. And it's said that by March 2025, so this 94% villages have been provided with the access. Now it is said that about 900 million people have also been given coverage. It's all right, the large number of people have been given access to the technology, but unless there is a digital literacy, you probably may not be able to beneficially use the technology for your advantage. There are people do have the mobile phones, but there is a lack of understanding. There is no access to the internet. Even if there is an access to the internet, there is illiteracy so far as the user and putting it to the use. These are certain problems which probably we have to overcome. As I have said earlier, we have made a tremendous transformation during last 20, 25, 30 years so far as the technological advancement is concerned. We will clear these hurdles also. But I may say that this is an emerging field. This emerging field is likely to pose unknown problems, and we may have to face the unknown problems and secure answers for these unknown in near future, and probably we have to be prepared for that. With these words, I stop here. Probably everybody is awake. Is it so? Then I hand over baton to my learned colleague, yes, Professor Madhusudan Rao. Thank you.
Good afternoon to all of you. Respected Justice R.M. Borde sir, former Judge Bombay High Court, Vice Chancellor Professor Surya Prakash, Vice Chancellor NLIU Bhopal, Professor Atul Kumar Pandey ji, and Sri Biswajit Dubey sir. Whenever a law is enacted for the purpose of regulating the rights of the individuals, then there is furor in the society. We are not looking into the objectives of the enactment. Simply first we oppose it. Some reputed judge was saying that the principal attitude of the people is to oppose whatever the government proposes. But that should not be the motto of the public domain when it comes to enactment of laws. Regulation as such is not a new one in India. Since the beginning of the Constitution, or even earlier than the Constitution came into force, we used to have a lot of regulation. And then some leverage is given after the Constitution came into force in the form of fundamental rights. And since then onwards, fundamental rights themselves have clearly laid out the outer limits to be for these rights. For example, Article 19(1)(a) gives one right, 19 Clause 2 puts a lot of restrictions on Article 19(1)(a). So this is not a new thing. Now a new law is enacted, still the rules are to be framed. Recently, the concerned minister in the central government stated that we just enacted the law. We have not framed the rules so far. We are framing the rules very soon. So at the time of framing the rules, we will take into account all the concerns laid, all the that are raised by the public domain. So consequently, what the government is saying is that there is no worry for you. Even then, in the public domain itself, in this, against this particular act, that is this 2023 Act, known as Digital Personal Data Protection Act. So there are certain concerns laid down by the public, or raised by the public. For example, we have already Right to Information Act, and then it got certain exemption provisions in Section 8. So one criticism leveled against this act is these exemptions are going to be diluted in favor of giving information concerning the privacy of the individuals in the society. Right to privacy is guaranteed by so-and-so judgment, Kupswam judgment, all the judgment they are citing. It's okay. Supposing if this exemption is widened for the purpose of disclosing personal information, and at the same time, the Right to Information Act protects this particular personal information, then there is a tussle between two enactments enacted by the same legislature. Consequently, which is to be given preference to is to be decided by the courts. So till that happens, there is no scope for get a lot of fear against this particular power. Secondly, rule-making power. It is alleged or it is criticized by the people saying that rule-making power is given to the central government, and then the central government may frame these rules arbitrarily. This is also not a correct line of approach, because every parent act gives power to the delegative for rule-making. This is not a new thing. We have already studied these things in our administrative law and all that. So at the time of framing the rule, if the central government abuses the discretionary power, because people are criticizing that a lot of discretionary power is given to the government for the purpose of making the rules, consequently the central government may abuse the power. That is the ground. If power is abused, consequently if the rules are made inconsistent with the parent act, what will happen? You know, the doctrine of substantive ultra vires will apply. So consequently there is no scope for any fear mongering concerning this particular power. And thirdly, this Data Protection Act has created one particular board known as the Data Protection Board. And these people are criticizing that, stating that this Data Protection Board is to be appointed by the government. Consequently, the government can appoint members at its whimsically, and thereby the government will muzzle the freedom of the individuals. If a law is enacted, the law lays down only the legislative policy. Details of implementing policy is given to the executive only. This is a normal right from India Delhi Laws Act onwards, 1951. There is no new thing in this. And then, if a power is given, what that is going on in the country now, supposing we have administrative agencies. For example, state governments have enacted laws for the purpose of establishing universities known as state universities. So state universities are established by the state government, and the governing bodies are members of the governing bodies are appointed by the state government itself. And these people are now criticizing that the government may misuse at the time of appointing these members. Logically, how the government can misuse it, in wherever you go, governmental interference is there in all the governmental institutions. This is a common practice. Simply because government is interfering, does it mean that the institutions are being ruined in the country? No. So this is another criticism leveled against this. There may be a governmental interference in the context of administering this data protection board. But this is also not convincing. And next one, this data protection board is digital by design according to Act. On this, people are saying that we have 95% inaccessibility so far as the internet is concerned in our country. They have shown this. I don't know from where they got this information. So in this way, there is no access for this data protection board. Just now, Honorable Judge has quoted everything. Even this criticism also need not be considered, because after sufficiently developing the technology in the country, by promoting the access, digital access to the people, then only the government is going to act on this as per the statement made by the concerned minister in the central government just 3 days back. And next one, personal privacy. Criticism is that there is personal privacy and sensitive personal privacy or sensitive personal data. What is the sensitive personal data? According to the critics, sensitive personal data means there may be biometric data, or there may be genetic data, or there may be this ADI collected data. So sensitive personal data as such is not recognized by the statute, the present law. Personal data is defined, but sensitive personal data, I think, is not defined it. So thereby these people are arguing that the government may disclose the sensitive personal data, or somebody may disclose the sensitive personal data also. Consequently, this must be protected. It's okay. The statement of the concerned minister gives the inference that all the concerns raised by the public will be taken into account at the time of framing the rules and regulations. Before parting with this, just I want to make one statement. Misuse of law is not a ground for repeal of law. People said that Third Act was largely misused. Consequently, it was repealed. What was repealed? One obnoxious provision was there in the law that was removed, and then all the provisions were added to the Unlawful Activities Prevention Act. Thereby, what these people have removed is only one particular provision. This one particular provision can be removed by amending the same act also, instead of repealing the entire act. You have repealed the entire act, and all the provisions you have added to the Unlawful Activities Prevention Act. How can you say that you have cured the act? Secondly, abuse of power is not a ground for denial of power. People tend to abuse the power. But at the same time, if power is denied, how to control the society? Power must be given, sufficient safeguards must be contained by the same law itself, so that the power will not be abused by the exercising authority. If these things are taken care of, then I think there is no problem for this particular law. Thank you very much.
May I request Professor Pandey to address the gathering? Thank you.
Justice R.M. Borde, chair of the session, and Professor Madhusudan Rao, professor from Andhra Pradesh University, Mr. Biswajit Dubey, Additional Advocate General Chhattisgarh, respected Vice Chancellor Sir, members of faculty, students, invited guests, and participants from other institutions. So, if I start with a question, rather discussing with the core concepts of cyberspace, cyber law, cyber security, and data privacy. So maybe I think I would be able to do justice, as I would like to join my previous speakers in saying that it's an afternoon session. So you are excused for your yawnings. I may also be excused for my burps. So the question is, because whatever we are discussing, that is revolving around computers, information technology, and cyberspace. Where is the cyberspace? Because we are talking about digital rights, and when we talk about rights, rights are territorial in nature, barring few. So in that context, first we need to limit cyberspace. Can we do that? So possible answer could be, it's everywhere and nowhere. You have a mobile phone, now that's a computer, by virtue of the provisions of the IT Act and as well as the judgment of the Andhra Pradesh High Court, Syed Asifuddin versus State of Andhra Pradesh, in which for the first time in 2006, court opined that mobile phone is also a computer if it fulfills the requirement that have been given in the definition of computer under the IT Act. So if you have mobile phone and you are connected to internet, you are part and parcel of cyberspace. That is space which has no respect for a physical boundary. The moment you are disconnected, that very moment you are not part of the cyberspace. So possible answer, or maybe a definite answer would be, it's everywhere. Cyberspace is everywhere and nowhere. Now, second question that arises in the context of internet, that what is the cyberspace? Because when we are going to talk about digital rights, and I'm not going to repeat some of the facts about digital rights as to what is digital right and under Indian Constitution, how it has been guaranteed, all those things have already been spoken. So we can discuss this question thoroughly, because what would constitute a cyberspace? So there are many technologies, there are many protocols, there are many procedures, and together this would create a new space, that is cyberspace. And cyberspace is being termed as the fifth domain, land, sea, air, space, and now cyberspace as the fifth domain. And when we look at the speed of technology, and particularly I would like to take light from the statement that was made by Justice Vivek Agrawal in the morning, when he says, when we look at the Supreme Court and judgments delivered by it, 75 years of Supreme Court, then judgments could be looked into three parts. One, 1952, 1975, then 75 to 2000, and 2000 to till date. So I would be talking about 2000 onwards. So in that context, we find that there are many components which would create cyberspace. The third question that is very important to understand and appreciate, who is the owner of this space? Because in case of land, it's a settled law. In case of air and space also, it is settled, almost settled. And space, next war or next war for right is likely to take place and already taking place, I would say. Now, in case of this cyberspace, who is the owner? Because this has no physical boundary. And this is a shared network, global network. So, everybody owns it, nobody owns it. I have a system that I have created here, for example. So in that case, routers, internet cables, internet facility which is available at NLIU Bhopal, for that purpose, university is the owner. Beyond that, university is not the owner. So similarly, when we are talking about a global network, so who owns it? So we cannot ignore the actors of cyberspace. There are various actors in cyberspace. One is definitely government. Other than government, we have many private players who are responsible for security of the internet cables which are connecting continents, which are responsible for developing protocols, rules, procedures for communication, because it requires. So, and then a concept of shared ownership has been developed. And in this shared ownership, we are talking about digital rights in a territorial sense. Now, when we look at the nature of cyberspace, like one example which I often quote, Facebook. If we look at the number of Facebook users in the country or on the Facebook itself, then total number of Facebook users, particularly female users, are double of the, or maybe more than total number of the female population in the country. जितनी महिलाएं पूरे विश्व में नहीं होंगी, उससे अधिक महिलाएं फेसबुक पर हैं. What does it indicate? It indicates that there are people who are there with fake identities, with fake account information. So how to deal with this? Will that be a digital right? Should it be a digital right? So that is another question. Now, as Justice Borde has pointed out, power of social media. So earlier we had technologies, and with those technologies, we were a town crier. But now, with the help of social media and digital technologies, one can post, one can make his voice heard throughout the globe. Because whatever we upload, that becomes a matter of global access, can be heard anywhere in any part of the world. So that is the power of social media. Now this power must be exercised, as it has been pointed out by Honorable Justice Pankaj Mittal in his opening remarks in the inaugural ceremony, that rights come with responsibility. So what about that responsibility part? Then moving further, there are certain interesting anecdotes I would like to share before I come to the core provisions, and I have been given to understand that I have more time among all the panelists. Recently, there was a case in UK where husband informed police that my wife has met with an accident and she is dead. Perhaps she is dead. Now, police reached to the scene of crime, and after making primary investigation, police almost concluded that it is a case of accident. But interestingly, police found a device, Alexa. Some of us would be using it. Now, Alexa was in on condition. Police wrote to the Amazon server where all the conversations which were recorded by Alexa were stored. Now, the conversation of last 72 hours were shared with the police, and it was found that husband and wife had heated arguments. And husband somehow, pushed the wife, and she fell, and her backside of her head collided with the edge of the bed, and hence she died. So now a case which was almost closed was converted into a different crime because of the data that was available. So mobile phones or other devices that we have, that we are using, it collects huge data about us. Even if I have a mobile phone, and if you just give it a try, if you are driving and using Google Map, sometimes it tells you. That's why sometimes I call that Google is not only guru, but it also a good mother. It will tell you, please take a tea break. So how that is being calculated? Maybe number of hours, number of kilometers, number of hours of driving. But in addition to that, it collects a lot of data. If you have put your phone in switched off mode and you are traveling from Bhopal to Delhi, that route would still be recorded by Google Map. So in that context, when we are talking about data protection laws and relevance of it, so we cannot do away with the technological understanding, the use of technology, because it is basically collecting huge data and processing it, sometimes without the knowledge of the users. Similarly, there is something known as Internet of Things. Now in Internet of Things, devices are connected with each other, where everything is connected. My mobile is connected to a smart city. So if I want to go to a shopping mall and need to understand whether there is a slot available for parking, I can do that. I can know that sitting at my place. Now a lot of data is being shared. So if I am using a smartwatch, it collects huge data, and that data is being processed. For what all purposes, nobody knows. Similarly, those who are taking part in challenges like पिछले जन्म में आप क्या थे, अगले जन्म में क्या बनेंगे? So Google or maybe Facebook is an astrologer now. Now huge data is being shared, and recently that your digital image, digital avatar, I think Ghibli. So in that case, it is collecting huge data. Do we care about that? So then there are uses of it that we know, and I'm basically trying to take you to the other side of it. Then there are other risks involved in the use of these technologies. Like in 2017, there was an attack that is popularly known as medical device attack. Pacemakers were installed. In IoT ecosystem, where things are connected, hospital would like to monitor patients with pacemaker in real time. And to be able to do that, they would have direct information from the pacemaker. And if there is any problem, immediately ambulance will be sent, and maybe the patient would be sent to nearby hospital, and all details of the patient would be shared. This is fine. But what if a hacker, so-called hacker, takes control of this pacemaker and threatens that I will switch it off? Will it not amount to cyber murder? So these are the challenges that we are encountering in the digital space. Then there is another incident which was recently reported in the newspapers. An AI advocate appeared in one of the courts of US, and a remark was made by the Supreme Court in this matter while asking an advocate whether you are an AI advocate or not. So these kind of challenges have been posed by the digital technologies, and in this context, we need to understand the digital rights, be it privacy rights or any other right that we are claiming or making a claim for that right. Then there are certain other challenges that we see, like cryptocurrency. Now, how Supreme Court, because this is Supreme Court and digital rights, so how Supreme Court is enforcing these rights? So in case of privacy, in case of other digital rights, some of the cases have already been quoted, but I would take one example, use of cryptocurrency. Whether use of cryptocurrency is legal. So initially RBI had a different stand. Later on this, RBI had issued some notifications banning it. Matter went to the Supreme Court. In Internet and Mobile Association of India case, wherein Supreme Court stated that cryptocurrencies per se are not banned. So whether it is legal or illegal, the status is not clear that way, because it is not illegal per se. So what kind of challenges are being posed by these novel technologies, these disruptive technologies? And then in that context, we have to look and appreciate the digital rights. Now, when we talk about specialization, particularly in the context of cyber law, so I would like to share an anecdote with you. In 2017, I was invited by Department of State, US, and Vice Chancellor Sir has also visited under the same program, I believe. So I was at MIT Internet Center, and a question was put to me. There were 8 professors who came for a meeting, and they introduced themselves. so first professor introduced himself that I specialize in big data and privacy. Other one introduced himself as that I specialize in human rights and privacy, non-personal data and privacy. So similarly, there were encryption and privacy, and so many other within privacy. There were many specialists, and then they put a question to me: "What do you teach over there?" So I could not answer this question, and the possible answer would be that Dean and Vice Chancellor would decide what I would teach in the next semester. Now, moving further, the kind of technologies we have and the kind of specialization we are talking about. So if somebody is not able to understand and appreciate AI, machine learning, may not be able to address the issues relating to legal issues relating to AI and machine learning, blockchain technology, and in case of other technology also it is very much true. So I would like to take you through certain cases which have been decided by Supreme Court to get back and be more specific on the topic. So the very important case, as it has already been pointed out by the chair, that is K.S. Puttaswamy versus Union of India. So for the first time, Supreme Court had recognized fundamental, though it has already been recognized through series of judgments which have been decided by the Supreme Court. But here Supreme Court categorically stated that right to privacy is a fundamental right. Then what was the outcome of this judgment, or in other words, impact of this judgment? The impact of this judgment is DPDP Act 2023, which has also been discussed. And a country like India, where concept of privacy is quite vague, and also it is quite fluid and cultural. For example, in India, if two families are boarding in a train and they are going for a long journey, what is that information they would not share? Maybe I'm not talking about Gen Z and Gen Alpha. Maybe I'm talking about the other generations. So they will start discussing with each other about family, job, salary, business, and sometimes before deboarding from the train, maybe they would end up in settling maybe a marriage proposal. So that is also possible. Now in this country, we have an enactment in the form of DPDP Act. As I said, it is quite cultural, because if you go to US, they will ask a question to you. Like in this particular gathering, did anybody ask, would you like to be photographed in the group? There is no such a culture. So here we will be photographed. I would not mind, and person taking photograph would also not mind. And when it comes to sharing of those photographs, nobody is going to ask. But there is a social media consent form which is required to be filled up, and signature will be taken. Now, fortunately, when we look at the provisions of the DPDP Act, these concerns have been taken into account, and it deals with right to privacy minutely, and the credit goes again to the Puttaswamy case. One example I would like to share: a person who joined a firm, multinational company, and he was asked to fill up a form wherein he would give information about himself, and one column was who should be contacted in case of medical emergency. Now he wrote the name of the person to be contacted in case of medical emergency. Next box was define the relationship. What is your relationship with the person whose name has been written? Now he had an objection to this, that I don't want to disclose the relationship, my relationship with that person. It could be my mother, my father, my brother, sibling, sibling, or maybe girlfriend, boyfriend, anybody could be. So now when we look at the provisions of the DPDP Act, all these things have been taken care of. No unnecessary information will be collected, and no information shall be transferred, processed without taking consent, and so many controls have been employed on the working of the data fiduciaries and users' rights have been defined. And another point when it comes to digital rights and the intervention of Supreme Court, which is very important, that is internet shutdowns. Now, in recent past, it has been seen that many times by way of executive orders, by implementing 144 of CRPC, orders were issued for internet shutdown. And the leading case on this point is Anuradha Bhasin versus Union of India, in which Supreme Court had basically, it has declared right to internet or right to access to internet as a part of Article 19(1)(a), Article 19(1)(g), Article 21, as well as Article 21(a). Because when we look at internet, and one more thing I would like to clarify, that as a student of computer science, in my, I would not say school days, university days, I read, internet is a medium to access platforms like www. Now that particular understanding is also defined. Because here, in today's context, internet means it's not a medium. Internet is a bigger term, is a wider term, which would take into account all the IT infrastructures, computer resource, networks, and digital platforms, digital learning platforms, educational platforms, even social media. So there are differences, but by and large now internet has acquired a secondary meaning, and we have to do away with the technical understanding that was developed with regard to the meaning of internet. So in the Anuradha Bhasin case, this observation was made by the Supreme Court of India, and it declared that right to internet or right to access to internet is a fundamental right. I'm not going into the facts of the case. In fact, there were other than J&K, Jammu and Kashmir, internet shutdown orders were also given in other states by the state government and respective agencies. But in the context of J&K, what was important that it was a prolonged shutdown, because temporarily it is being imposed to achieve a particular objective, which is very much permitted under Article 19, Clause 2. And to carry out the spirit of Article 19, Clause 2, whatever enactments or provisions have been introduced in different legislations, so under those provisions, these internet shutdown orders were issued. But internet is shut down for months and years. So in this case, Supreme Court made another important observation, that all the orders of internet shutdown shall be subjected to judicial review. They shall be subject matter of judicial review. And second, unnecessary, unreasonably, internet shutdowns must not be ordered, and particularly prolonged shutdowns of internet must not be ordered. Not only that, now if we look at the technology in certain countries where internet shutdowns were ordered, people found another way to connect, like in when protest was going in Hong Kong, internet was shut down. And needless to say that what kind of shutdown order would have been there in place. So they created a mesh network. Like I have mobile phone, so it can connect to a device in 10 meters radius. So my phone is connected to your phone is connected to another person, and this is how the whole city was connected. Now, if we go in the deeper understanding of this judgment, those kind of rights are also protected. It is not only internet, anything which is connecting, any digital technology that is connecting people. It could be Bluetooth, it could be any other technology. So as I said, in this case, the Supreme Court in the month of January 2020 ruled that internet to be a fundamental right, and restrictions must be imposed with all due care and attention. Now, moving further, the test of proportionality and restricting fundamental rights, that has already been touched upon by Justice Borde, so I am not going into details of that. Now, Foundation for Media Professionals. A writ petition was found by this organization of media houses, and basically it is arguing that there is an urgent need to regulate the search and seizure procedure for digital devices in India. The petition claimed that existing legal framework under various penal statutes is inadequate to cover digital devices. Now, whether this right or this demand is reasonable, lawful, so let me take an example. I have a mobile phone, and in that mobile phone I am accessing I am accessing Gmail, I am accessing my official accounts, personal accounts. I am also using my WhatsApp account. Maybe I am informing and I could be vulnerable because of this information, but still, photographs, other information, maybe classified information, maybe some business information, all that I am storing in my mobile phone. Some screenshots I have taken. I am saying it purposefully. Now, in a particular investigation, if my mobile phone is to be accessed by the law enforcement, so in that context, what all information they would access? If they are accessing my laptop, what all information they would access? The information contained in Drive E, the information contained in Drive D. So again, it is a question. So what should, because this is my right to privacy is infringed. If somebody is somebody is accessing my mobile phone without any check and control. So my private photographs, videos, all that may go to the in hands of those persons. So this demand has been made. And another case, similar case, that is Ram Ramaswamy versus. This is a case that was filed by a group of academicians, and in this particular case, Ram Ramaswamy versus Union of India. This case has been filed by the group of particular writ petition. Academicians are seeking guidelines for the police on search and seizure, preservation of personal devices. Earlier, there was guideline in some of the SOPs of the law enforcers, like if they are looking for, say, .jpg files, so they would make search for .jpg files only. So in that case, no other file would be accessed. But now in today's time, it is not possible, because a person has taken a screenshot of an Excel file, has taken a screenshot of a presentation, and then that is being saved in the form of .jpg files. So this kind of searching may not help to law enforcement. So here, Supreme Court has directed central government to frame rules, because the SOPs which are being used by the different law enforcement agencies, they do not have any guideline on that. Another example I would like to take, another problem in fact I would like to highlight, that is use of drone. Suppose that, again if I take example of a law enforcement which is flying a drone, or anybody is flying a drone, and then he wants to capture certain scenic arrangements, but because that camera is recording so many things, it would record the information about unrelated parties as well. And if the same is to be presented in the court of law, that would become public document, and that would have a bearing on the right to privacy of the other person. So in what manner these evidences are to be collected and to be produced before the court of law for its appreciation and understanding. Then another case, that is Kunal Kamra versus Union of India. In this case, the intermediaries rules, Rule 3, subsection 1, clause B was challenged. Now it basically puts emphasis that intermediaries must check certain facts before they are posting it, and this is basically FCU unit of the government. Now, this particular, in this particular case, the working of FCU, the functions of FCU has been challenged, and there are other cases. In the interest of time, I may not be discussing that. But last point, use of Tor and encryption. Now, one problem that we may see in the context of use of these technologies, those who are admirer of freedom of expression, those who are admirer of human rights, they would argue, advocate that technology like Tor, technology like encryption must be allowed to be used without any check and control. But we should also look at the rights of the other rights of the state, particularly the law enforcement agencies. Like if they have to investigate a particular matter, they may not be able to bypass that encryption and may not be able to collect evidences, particularly about the anonymous postings and anonymous working on the internet. So with this, I close my talk, and over to you, sir. Thank you.
Hello. Thank you, Professor Pandey, for giving this insightful picture of the subject. May I now request Mr. Dubey, Biswajit Dubey, to address the gathering.
Thank you, Justice Bode, and thank you, Professor Madhusudan Rao, and thank you, Professor Atul Kumar Pandey. I think all of you spoke so well, and it was such a detailed session that there is nothing much that I need to add, but I would just speak about some general things and the perspective that I have. And again, I must once again repeat that I am actually honored to be speaking with this panel before very honorable people, personally and professionally speaking insofar as I am concerned. And especially speaking here is always a pleasure for me and a matter of pride for me. I still can't believe that I actually left this place almost about 21 years ago. And we are speaking in front of all of you. Anyways, coming back to the topic. So when we talk about internet, my first encounter with internet, because it was only in Bhopal, was sometime in the year 2000 and 2001 as a student, to seek some help because we were supposed to make certain projects in every subject and we had to do presentations. So that started with that fact. We were not aware or not concerned about rights, privacy, etc., anything. We just were seeking help, and then we created our email IDs, some random email IDs, names to begin with, and then to more better and formal names. But as we grew, all of us, I mean, I guess that most people in India started using internet maybe 2-3 years before that or after that. But no one really was initially concerned about any rights surrounding it. We were mostly using it to collect data and information mostly for academic purposes. But then, of course, the scope expanded. I belong to the generation which was on the Orkut. It saw the peak of Orkut, and then Orkut died. And then Facebook took over. A lot of you here may not even have perhaps heard of Orkut, but Orkut used to be much bigger than Facebook is today, or maybe Instagram. It was something very, very different. Anyways, coming to the point on understanding digital rights, a lot has been spoken. So I'll just summarize, is that when we talk about rights insofar as internet or digital world is concerned, if I have to summarize, I'll say it is the right to privacy. Important because a lot of our data we voluntarily give to a lot of private agencies without realizing. We simply sign up to anything and everything. We sign up to so many apps, and they say there is a longish agreement for you to sign, or you have to say, okay, you okay it and move on. So we don't even realize that perhaps we may have given access to a lot of information that is there on our phones or on our laptop. So one, how the data is being used. So therefore, my data, my right to privacy is with respect to that data. That is still perhaps to some extent where I have volunteered. Maybe how much of it is thought or considered decision whether I'm, insofar as I'm submitting the data is concerned. But having said that, there is perhaps some level of consent there. Second is where we submit a lot of information to the government for various reasons, which is where the Aadhaar became a very, very controversial issue at some point. So when we submit that data to the government, whether government can use it, of course, can misuse it, possibly. Therefore, the right to privacy, when we talk about enforcement, it becomes very, very important there also, because ultimately that data is not really with the government or some, it can be accessed by some person who may use it against me or you, etc. So therefore, it's a bit of a concern. Then second important part is the freedom of expression, and freedom of expression insofar as this topic is concerned, freedom of expression online. Now, in our day and age, and I think I belong to that age which actually has seen a lot of transition, where Justice Bode spoke about the fact that we saw when there was no light. I belong to that generation which has seen that. And perhaps there are, thankfully, I mean, even today we witnessed some few seconds of it. But for us, it was actually to some extent a happy occasion as kids, because we would, with our parents, maybe do some stargazing because there was no light, and it was a happy occasion. Either you read through the lantern or laltern, as you used to call it, or you do stargazing with your parents and get to spend some time with your parents. Today, my daughter, she's 8+ years old. She can use my phone better than I can do. And this is something that I'm stating as a matter of fact. I'm not saying whether I'm happy or unhappy about it, but this is true. She can teach me how to use my phone. So therefore, this is such a huge transition from where we were and where the world is today. We are catching up. And insofar as Mr. Pandey somewhere pointed out when he was talking about his US trip, is that there was specialization in specialization. And he rightly said that here what he's supposed to specialize or teach is what he is told. But fact is that we live in a country where a student or any society or any community that we talk about will have a variety of people. There will be one person who's almost perhaps very low insofar as understanding that particular subject is concerned, from someone at the other end who understands almost everything and maybe even can challenge the teacher himself. So there is so much variety, and in that you have to find the right balance to be able to teach them. It is not really easy. Anyways, I diverted there. Coming back to the topic on freedom of expression. So when I had to speak ill about someone, gossip about someone, I would just do it to maybe 1 person, 2 person, or 3 people in person. But in today's time and age, you can actually talk about any random people. That person may not even know you. On the internet or on WhatsApp. So on the one hand, we need to be mindful of the fact that whether I have the right to say anything about anyone. Second is whether that person has a right to feel offensive about what has been said about him. Now, I think there is the law around it. There has to be something around it, that the judgment we spoke about where 66A of the IT Act was eventually struck down, where anything offensive on the internet could actually become a ground for arrest for someone. So I think the judgment from the Supreme Court was correct. But having said that, do we even think about the duty that we may have towards others? It's very easy to speak ill about anyone else. But at times we are randomly sitting in some corner without realizing the situation of the other person and start posting anything and everything about anyone. So while there is freedom of expression, but then there is a sense of duty as to what we should post and what we should speak about others, particularly when we are posting it online, which is available to the world at large. So then third aspect is about data protection and informational autonomy. Again, that is somewhere linked to right to privacy according to me. The point is that when I am submitting data voluntarily or involuntarily or whatever the situation may be, that data needs to be protected. At times it is very, very common these days that I go for shopping and they ask you for your phone number. Now I have started saying that why do you need it, right? Because at a very simple level, it becomes a hassle because I don't know who takes that number from them, and I start getting calls ki aap ye le lijiye, wo le lijiye. Half the time we are supposed to keep buying something or the other for someone. So that is actually a violation of my right. My data, my phone number is my data. I do not want to share it with anyone and everyone. Then the next aspect is right to access the internet. In the J&K case that Mr. Pandey spoke about, the court rightly has recognized that the right to access internet is a fundamental right in today's age and time, because we actually cannot function. And I can say with some sort of authority that anyone sitting in this room, for example, if any of us is asked that can you survive without internet for a week, I think it will become impossible. Even if we go try and buy something, we need our phone, we need internet to be able to make that payment. So the point is that even for educational purposes, as I think Professor Madhusudan said, that you need internet for so many things. Of course it is misused, that's a separate matter, but even for your genuine needs, you need that. So therefore, whether it can actually be shut down for a prolonged period, the answer to that Supreme Court gave was that no, you cannot. Of course, for security reasons, at times it becomes important. Like we have seen some cases where some WhatsApp forwards are used, and it becomes a trouble for some people in that area. So therefore, that is very, very important. That is some check on it. Internet shutdown for a brief period, yes, because of security reasons, it can be done because you are trying to achieve something. But for prolonged period, I think there is a problem there. And last point is about unlawful surveillance, which is again very, very important, because today my movement, what I speak on my phone, to the extent that what I speak around my phone, even when my phone is not on, and I'm sure a lot of you have seen that the phones respond to, different phones to, some would respond to Hi Siri, or some other phones would respond to something else, which means that your phone is listening. At times, I may not even have said Hi Siri, but I utter some word, or I'm talking to someone, it recognizes it as Hi Siri, and maybe it starts responding. The point is that even when I am not using my phone, it is lying idle somewhere, it is listening to what I am saying. Should I be concerned about it? As of now, I don't think most of us are concerned about it, but it is also something that is a matter of concern, because that can be used by private or public authority to keep some sort of surveillance on me as to who I am talking to, when I am talking to, what I am talking to, what is my movement. So these are some cause of concerns. I would say that largely so far, insofar as Supreme Court and other courts are concerned, largely I have taken a very balanced and right approach, and we hope that that continues. Even the government is taking the right steps in the direction. But yes, there are several questions, because as I said, as a society, as a country, we are trying to catch up. We are still not there where we should be, and on that, I think that one thought could be that to have younger people who actually understand internet and internet devices better than people like me or the generation which is senior to us. I'm sure there are people who are senior to us, they also understand, but maybe we need some very young blood on whenever we are enacting any law, or there is some discussion in the judgment, they should seek help from experts, including people who are young and understand this better. With that, thanks again. And thank you again for patiently hearing me out. Hope no one felt asleep in in this session, because post-lunch it is always difficult. Thank you.
Thank you, Mr. Dubey, for this intellectual discourse. I think now it's 4 o'clock. it's a tea break. So we dispense with the questions and answers, and I declare the session to be over. Thank you so much for listening to us patiently. Thank you.
I thank all the panelists. We can all proceed for high tea. Thank you. The next session will start at 4:30. I request everybody to please be seated and allow the guests to proceed first. Thank you.
Good evening, one and all. A very good evening to the respected chair, Professor A. Lakshminath, and our distinguished speakers, Mr. Saurabh Mishra, Mr. Sankalp Kochar, Shri Apoorv Mishra, and to all the members of the audience. Welcome to the special podcast session on the Supreme Court and its imprint on India's legal landscape and society. Since this is a podcast session, it would be recorded and uploaded on all official university social media handles. I would request the panelists to please come onto the dais. We would like to begin by expressing our sincere gratitude and by formally honoring our distinguished guests joining us today. We have small tokens of our appreciation for each of our esteemed speakers as a mark of welcome. Now I would request our respected registrar, Mr. Vivek Bakshi sir, to kindly felicitate our esteemed panelists. Thank you, respected sir, for doing the honors and formally welcoming our guests with these tokens. Leading our discussion today is the esteemed chairperson, Professor A. Lakshminath, who is a distinguished figure in legal academia and presently distinguished professor emeritus and professor at NLIU. His over 5-decade career includes foundational leadership roles, notably as founder VC of CNLU Patna and founder chancellor of DSNLU Vishakhapatnam. His contributions have been recognized by awards like the Professor Madhav Menon Best Law Teacher Prize, and the late Padam Shri Professor Madhav Menon aptly described him as an institution by himself. Professor Lakshminath, your journey is one of extraordinary dedication and impact. We are profoundly honored by your presence and deeply grateful you agreed to chair this discussion. Please welcome Professor A. Lakshminath. Welcome, sir. We would also welcome Mr. Saurabh Mishra from the NLIU class of 2004, now Senior Advocate of the Supreme Court and Additional Advocate General for Madhya Pradesh. His extensive experience includes over a decade as advocate on record at the Apex Court before his resignation as Senior Advocate. Representing our home state, his insights offer a crucial perspective. Mr. Mishra, a very warm welcome back to NLIU. We are honored by your presence and sincerely thank you for joining our panel today. Thank you, sir. Continuing with our panel of esteemed experts, it is now my pleasure to introduce Mr. Sankalp Kochar. We are particularly delighted to welcome Mr. Kochar back to NLIU Bhopal, as he is not only a distinguished alumnus, but has also previously served this very institution as its standing counsel for over a decade. Following his legal education here at NLIU, Mr. Kochar further academic distinction by obtaining the prestigious Bachelor of Civil Law degree from the University of Oxford. For over 18 years, Mr. Kochar has built a significant independent legal practice, focusing primarily on the High Court of Madhya Pradesh across its benches in Jabalpur, Indore, and Gwalior, as well as the High Court of Chhattisgarh. Mr. Kochar, a warm welcome back to your alma mater. We are honored to have you and sincerely thank you for participating. Welcome, sir. Completing our distinguished panel today is Shri Apoorv Kumar Mishra. It's a distinct pleasure to welcome him back to NLIU Bhopal, as Shri Mishra is a distinguished alumnus holding his law degree from this very institution and has also generously shared his experience by teaching here in the past. Currently, Shri Mishra serves as a consultant at the Economic Advisory Council to the Prime Minister. He operates at the critical intersection where legal framework meets economic realities and governance challenges. Shri Mishra, a very warm welcome back to NLIU. We are truly grateful for your presence. Welcome, sir. Thank you once again to our esteemed panelists. Having formally welcomed and honored our guests, we are now truly eager to begin our exploration of the Supreme Court's imprint on India's legal landscape and society. Without further ado, let's commence. Please, sir.
Thank you. My fellow panel members of this podcast session, this is the last session of the day. Distinguished audience, friends, and I may have to say chairs, because most of the chairs are vacant. Those chairs also become the audience. Well, friends, this is a podcast session. I don't know what exactly it means. Somebody said it is iPod plus broadcast. I think all is broadcast here. I don't know who the speakers will be, but iPod is not there. Well, friends, this session is about the Supreme Court and its imprint on the Indian legal landscape and society. I was briefed, I should be like a speaker in the Parlok Sabha, sorry, not Lok Sabha, not Parlok Sabha. Speaker means one who does not speak. That is what goes on in the Lok Sabha. So chairman means one who should not speak much. So I should allow others to speak. As it is, I think session has started a little bit late because you have all come and see a little bit leisurely, because now we see we have to start at 4:30. Now it has become almost 5. If I don't finish my session by 6, I think you all will curse me. So I want to get away from the curses, and I request my panelists also to observe the temporal limits. I think we have 3 people. I don't take much time. I give you as much time as you please. And before that, I wish to congratulate the Students Bar Association, and I doubly want to thank them for having arranged these sessions, which in fact, now suppose they say bar, bench, and beyond. But they are forgetting their mic. Starting academics, but don't jump to the bar. Bar, see, is of two kinds, that is different. Then bench, academia, bar, bench, and beyond. And in fact, that beyond is about the session today. What is the impact of the Supreme Court and its decisions on the society? What is its impact on the landscape? Should we think of rivers? What is the impact of people on the court? See, this impact, see, we as law students, law practitioners, and law interpreters, we are concerned only one type of prudence. Prudence. What is a systematic knowledge? We are concerned with jurisprudence. In fact, the day on which he entered the portals of the college, jurisprudence, अरे बहुत भयानक subject है, कुछ नहीं है इसमें. There are certain principles, precepts, standards to be taught, that too abstract. And unfortunately, we concentrate only on the courts. What this court has said, what this judge has said, what this judge has said, what this bench has said, what that bench has said. And beyond that, we don't discuss. That is what we call jurisprudence. That means prudence only of jurist, not beyond that. But how much law is made in the courts? Is it law that is made in the court? That is what is known as now case-to-case basis. It is court culture. They decide a case, individual to individual. But we have to change the culture of the court. We have to change the concept of law itself, how it does. So as compared to this, or as distinguished from this, we have what we call legisprudence. That means the prudence, a systematic knowledge of how the law is made. Bulk of the knowledge is made by the legislature. And they are the people who are representing us. Because we speak through them. What do we want? As morning I said, aspirational, ascribed majorities and minorities. That is the spokesperson of the people. What they do, and by making the law, is what is known as jurisprudence. And that, of course, known as a protector of the Constitution, the judiciary will take care of it, and that prudence is transformed into jurisprudence. The next most important is that, what were these laws? Not the legislators. They only make the laws only to break them. But by making a law, they create a norm, and the norm has to be observed by us, because it is a prescriptive one. We have to abide by it. If there is a breach of this norm, we are punished. It is for the bulk. How do we change the law? What is the impact of that law? Let us say Dowry Prohibition Act is made in 1961. What's the impact? No impact. But how the democracy, or how the democratic power, or how the democratic force changes the course of law through the institution of the courts. This is what we call prudence through demos, through the people. This is in fact the major contribution of the Indian Supreme Court, where they have opened the gates of the locus standi rule. The locus standi rule, which is fiat justitia, do according to, if you have got a standing, then only you come. Other doors are closed. No. Public interest litigation, anybody can file any case from anywhere. The Supreme Court. You can address Supreme Court, Mr. Krishna here, I am having this difficulty. He will immediately treat this as a writ petition, and then it is taken as PIL, public interest litigation. Why, friends, why are you going? This is meant for you only. So this public interest litigation has made immense impact on the course of law. The law has changed. Victim compensation, which you do not know, has made a significant change, though there is no law. Because a sociologist by name Vasudha Dagamwar, she went into Bihar jail and just found out one person by name Rudul Shah. She has asked him, "Bhai, what are you doing? Since how long you are here?" "Madam, I don't know." "What is that? What crime you have committed?" "I don't know." Well, then she asked the jail authorities. They said, "I don't know." She asked the police people. They don't know. They asked the jail, the court. And the court record, Rudul Shah appeared, he was acquitted. For 30 years, he was languishing in the jails for 30 years for not committing any crime. That has been converted into public interest litigation, and from them onwards, what is that? How you compensate for the 30 years loss of his youth? If you remember those elders, there is a picture also on this Adalat or something like that. So how this democracy is going to impact, how the court has impacted minority rights. It has impacted, it has used as a balancer. And similarly, how we are able to say sexual offense at the workplace. There was no law. Only just there was a convention from the United Nations. Only on that basis the court has taken up, and that has been converted into a law. Education, no, we don't know. We have a right to education. But because the capitation fees and these people went to the court and people transformed, this is what is transformative constitutionalism, transformed the court's mind so that they could see that a law is made, and thereby education has become a constitution, that to fundamental right, Article 21A. So this is the impact of the court's judgment. But how the courts are impacted, sometimes they take suo motu, sometimes they cannot. Then who will do that? We people. Because a lawyer argues for case. Case means money. It is case law. Whereas this is what we see, transform the law. This is, you are to see, reforming the law itself. That is people, that is demos. How people try to interact with the court and they change the culture of the court itself. This is what we call demos prudence. And how we can criticize responsibly. That means a responsible criticism, that social responsible criticism or socially responsible criticism. If it is this, with this, we'll be able to discuss what is the impact of the court decision on the people and what is the impact of democratic forces on the court to change the law. Or see, there is a cultural shift. And please, I request you, if you can throw some light on this, I'd be very happy. See that you can take 15 minutes each, and I hope you will bear it. I assure you, we'll complete 5 minutes before 6. Thank you. Saurav Mishra ji.
May I first congratulate NLIU and Professor Suripaka and all the wonderful team who's organized this first law conclave. I'm here in the capacity as a lawyer practicing in the Supreme Court, but I must acknowledge that whatever little that I have become is because of the wonderful teachers who are present here, who have taught us. And I want to tell all the students who are sitting here that while you are studying here, you will be facing several problems. And but I must tell you from experience that after we also faced several problems while we were studying here, and after we passed out, 5, 6, 7, 8 years down the line, when we were more stable in the profession, when we got a little recognition, when we started making a little more money, then we realized the importance of this institution and the teachers who have taught us. On that note, with Professor's permission, may I address on the subject that we are here to speak upon. The subject is the impact of the Supreme Court on the on the Indian landscape. The Supreme Court internationally is regarded as one of the most powerful courts in the world. Now, I can speak about its impact as a constitutional law student and as a practicing lawyer of the Supreme Court. And so in second part, I can share my own experiences as a lawyer who's practiced before that particular court. Now, what makes the Supreme Court so powerful? It is because of the powers, firstly, that are vested in the Supreme Court under the Constitution. The Constitution, under Article 32, all of you constitutional law students would know that, guarantees every citizen right to constitutional remedy. Any citizen can approach the Supreme Court in its original jurisdiction to enforce its fundamental rights. The Supreme Court is the final court of appeal on all civil constitutional matters. Provisions starting from 131 to 135, the court has original jurisdiction deciding disputes between states and the union. Then high courts can grant certificate of fitness of appeal, and statutory appeals lies to the Supreme Court. 136 of the Constitution confers discretionary jurisdiction to the Supreme Court, and against any order passed by any court or tribunal, a special leave petition to the Supreme Court is available. So that is the expanse of the power of the Supreme Court, which is vested under the Constitution. Apart from that, what makes the Supreme Court powerful is by the judicial decisions that it has given under its power of judicial review. By judicial review, the court has assumed the power to strike down legislations and even constitutional amendments. I need not go in detail on those aspects. All of us are aware about that. In the 80s, the court started with the public interest litigation, which Professor Saab was earlier referring to. And the traditional rule of locus standi was given a go-by. Anyone espousing a public cause can approach the Supreme Court directly. And we have seen the difference this particular exercise of jurisdiction by the Supreme Court has made on the impact of the society. I've been living in Delhi for almost 20 years, and the orders passed by the Supreme Court with regard to conversion of all buses to CNG, autos to CNG, shifting of all polluting industries out of the Delhi area, it has, although still, I must say Delhi is still not so livable in terms of pollution, but the impact is there on the ground. There are several other areas with regard to prisoners' rights, etc. Again, I need not go into detail, but these decisions of the Supreme Court have made a big impact on the lives of the people. As we moved from 80s to the 90s, under the Constitution, originally, the power to appoint judges of the Supreme Court or the High Court vested with the central government. By judicial interpretation in the second judge's case, the Supreme Court interpreted the word consultation as concurrence, and a collegium system was devised where the collegium of the Supreme Court will make a recommendation to the government on appointment of judges, and the government can only refer it back once. If it is referred back, then the government is bound to make that appointment. So this is where, by judicial interpretation, the Supreme Court has assumed the power to appoint judges both in the High Court as well as the Supreme Court. coming back to my experience as practicing lawyer in the Supreme Court, we have 34 judges in the Supreme Court, and a minimum of 2 judges are to be there on a bench. So the maximum benches that are available at any given point in time is 17. And the number of pending cases in the Supreme Court today is 70,000. So while the 80% of Supreme Court's litigation is by special leave petition and most cases are dismissed on day 1, even assuming you are lucky and notice is issued in your case, getting the case listed in itself is a daunting task. We have the Supreme Court originally was conceived to be a constitutional court which will lay down the law, which will bind all the high courts. But in my experience, what I find is when I prepare for a particular case and I try to find the case law in support of my case, invariably, I will find that there are conflicting decisions of the Supreme Court on almost every subject. So the original thought process of having the Supreme Court to lay down the law and give clarity for the subordinate judiciary to follow is not significantly achieved. The Supreme Court originally was thought to be a constitutional court for laying down law and not to hear routine cases. But in my experience, Supreme Court is almost 30% litigation of the court is service matters, 20% is for bail. There are several judgments of the Supreme Court on criminal cases for grant of regular bails, anticipated bails. Law students and as lawyers, we have a very important and critical role to play as a stakeholder of ensuring that the independence of judiciary is maintained and its impact of changing on the ground continues. Thank you.
Good evening, everyone. The topic is very interesting, saying the role of the Supreme Court. I was just thinking, Saurabh sir was talking about what the Supreme Court did. I think the biggest thing the Supreme Court has done is legislate. How many laws have the legislature passed? We can count maybe 200, 500, 1,000, 1,500. But I think the biggest legislation comes from Article 141 of the Constitution of India, where it says everything what the Supreme Court says is the law of the land. And I completely agree that every judgment which the Supreme Court gives is contradictory to the other. Now then we'll think, what's the law of the land? Nobody knows that actually. Every judgment which comes up from the Supreme Court, there would be an equally conflicting coordinate bench judgment. There will be an equally conflicting idea, the premise would be different. So the question is, what is the power of the Supreme Court? I think the soul of the power of the Supreme Court is Article 141. And that is precisely what the Supreme Court has done for the past 75 years. And I can talk about the social impact, the economic impact, the constitutional impact, the legal impact the Supreme Court has had. Let's talk about how the Supreme Court takes up things which are completely alien to it. Someone like a judgment in Sabrimala, where everything is argued before the Supreme Court, right from scriptures, Veds, Purans, everything. And the Supreme Court is supposed to digest everything and then give a judgment on whether Sabrimala is an archaic law, whether we are supposed to allow females to enter the temple. And that Supreme Court judge is supposed to give and understand the Veds, Purans, Upanishads, and then give a judgment on it. And that becomes the law of the land. Equally, when Section 377, homosexuality, is decriminalized, a Supreme Court judge is to give his opinion about what is there in the mind of a homosexual. whether in our present day society it is acceptable. You would understand this, US has 52 states and every state has its own law on homosexuality and whether same-sex marriages are allowed or not. So in US, there are few states where homosexuality and same-sex marriages are legal. In other states, it is illegal. India possibly is the only country where one thing stated by the Supreme Court becomes the law of the land very second day. So quite interestingly, when 377 was decriminalized, the next thing which popped up was same-sex marriage. Obviously, once you climb the first ladder, you go to the second. You want to go to the second floor. And what is being argued before the Supreme Court? What is being argued is now you should accept same-sex marriages. Now the biggest and the wonderful argument which came from one of the people who were opposing it was, sir, they have a cause, they don't have a case. What does that mean? Means, yes, they have a cause. They have a cause that, yes, two people belonging to the same sex want to reside together and they live their life peacefully. It's a cause, but it's not a case. Why it's not a case? It's not a case because it does not fall within the legal framework. For the Supreme Court to say that, yes, we would be the people who will allow you to stay together. Now, who would allow that? The Supreme Court says it's the legislature. The legislature, assuming for a moment, comes up with a legislation that same-sex marriages are allowed. Up comes the second petition, challenging the very same legislation, saying that it is contrary to our constitutional principles. Now again, who has to decide this? Again, the Supreme Court. Eventually, if you see everything which is done, right from we were talking about the basic structure, we talk about every law which is there under the sun. Let's take up Joseph Shine, a very archaic law, 150-year-old adultery law, and a funny law at that, that if a particular person gets into an adulterous relationship with wife of another, only that man can be prosecuted, the woman cannot be. You know what was the ground of challenge? The ground was challenge was inequality. The funny part is, the woman cannot be actually sued and she cannot be criminally tried for that offense, but the man can be. And the biggest argument was, why can't the woman be also criminalized under this offense? And therefore, on the ground of equality, that law was struck down. 497 of IPC. So you see the inherent contradiction where a woman is actually, she is shielded from being prosecuted. But by this law, now she can also be prosecuted. But this was on the touchstone of equality and inequality. So what I'm trying to say is, the Supreme Court, as on date, is supposed to know everything. Is supposed to decide everything. Is it on constitutional principles? It's an argument to be made. But what I think is, where the legislature is not performing its job, where the executive is not performing its job, is the Supreme Court who is legislating on every point. Let's take an argument on 370. Again, the same thing as to whether 370 and why it was supposed to be, and the second argument which was concomitant to this was the argument of reservation, which was supposed to be there for 10 years only, as the framers of the Constitution said that. Now we are in the 75th year, whether reservation is supposed to be there or not is something which is being argued in the Supreme Court, whereas it should have been something which should have been decided by the legislature. The entire creamy layer argument, what Indira Sahani versus Union of India said, everything comes down to the courts. Everything comes down to the Supreme Court. Now compare it with the Supreme Court of the United States of America. United States of America decides about 90 cases in a year. Only 90 cases. Only constitutional principles and constitutional arguments where before the matter is argued in the Supreme Court. I'll just give an illustration. Neil Katyal is one of the leading lawyers in the Supreme Court of US. He argues about 60% of these cases in the US Supreme Court. And before he actually makes an argument before the US Supreme Court, there are 3 mock trials or 4 mock trials which happen before he eventually argues before the Supreme Court. And those mock trials happen before sitting High Court judges and other academics. And this includes professors from various universities in the US. After that mock trial happens, which is completely funded by clients, he's paid for every minute he actually spends on that brief. Those mock trials happen where it is recorded. These professors from the universities, these judges from the high courts would give their feedback. and eventually after 6 months he'll go to the Supreme Court, where he'll be given 90 minutes of the time of the Supreme Court to argue the matter, where he is well rehearsed, where every point is well rehearsed, every argument is tested on the touchstone of constitutionality, and then the US Supreme Court decides those issues. Now compare it with what Saurabh sir was talking about, whether the Supreme Court ever has the time and whether it will ever be able to decide such constitutional issues in this country, where it has to deal with roughly about 100 cases every bench has to hear on a miscellaneous day. So with this, I really think that we are actually losing the very constitutional principles for which the Supreme Court was established. It is becoming actually a court of appeal as if it's a municipal court, where the real issues are not decided, where the real time which should actually be spent on real issues, where the legislature and the executive is not able to. We're spending our time on bail applications, we're spending our time on other things where the Supreme Court is just supposed to decide on constitutional principles arising from other higher courts. So I think we really need to look at how the Supreme Court functions and whether Supreme Court is the only court which is actually legislating on the issues under the garb of Article 141. Thank you.
Thank you so much. Let me begin by saying that this is a bit like homecoming. So many people in the first 2 rows have seen me grown up, that I'm delighted to be in your presence. Let me begin by first thanking Dr. Akarya, Professor Surya Prakash, and the entire Student Bar Association for putting this wonderful event together and for your kind invitation. I say this is homecoming because the advantage of coming home is that you can have a frank conversation with your family members. We are here to celebrate 75 years of the Supreme Court, which is an extraordinary institution whose journey has shaped the life of our republic and its citizens. But I want to limit my comments to the role of the Supreme Court in the economic life of our country. Because courts don't just perform a moral and a social function in a society, but they also perform an economic function, even when they're deciding non-economic issues. Because every policy choice you make has costs and benefits which are imposed on society. And so I want to have a frank conversation with all of you about the role of the Supreme Court in the economic life of our country. But let me just preface my comments by saying that these are my personal views, and these are not the views of the organization that I work for. Our Constitution guarantees economic justice to all citizens. And despite this constitutional promise, and despite the fact that since independence, every politician and every policy was focused on alleviating poverty, we made modest gains in improving the lives of our citizens till 1991. It is only when our country began to experience economic growth in 1991 that our performance on human development indicators began to improve. There is a UNDP report which came out in 2023, which said that between 2005 and 2021, 415 million Indians were lifted out of poverty, as per the Multidimensional Poverty Index. 415 million people in just those 15 years. It's almost the population of entire European Union. This was possible because of the economic growth that our country experienced in the last 4 decades. And so today, there is political consensus across the political spectrum that the surest way to improve the lives of our citizens is to deliver economic growth. Now, depending on which party is in power, the focus areas and the speed and the strategy might change. But there is political consensus across the aisle, except a fringe communist left, which is no longer relevant in our country, that the surest way to deliver economic growth to our citizens is to improve the lives of our citizens is to deliver economic growth. However, it is not just the political establishment that decides the economic destiny of its citizens. The performance of the judiciary also shapes the economic performance of a country. And any discussion on the role of the judiciary in the economic performance of a country must start by stating the obvious, which is something that Sankalp sir alluded to, which is that our Supreme Court has extraordinary powers of judicial review in this country. The kind of powers that would make Justice John Marshall blush. Justice John Marshall, as you know, was the inventor of the modern doctrine of judicial review in Madbury versus Madison. While a lot of good has been unlocked because of this extraordinary power of judicial review, some of which was alluded to by the previous three speakers, we've allowed judicial creativity to create tools to guarantee political and civil rights to our citizens. The invention of PIL, the entire set of cases on environmental protection, the basic structured doctrine, protecting judicial independence. But equally, the expansive power of judicial review means that today, courts are not just the forum for settling disputes of law, but they're also a forum for settling disputes of policy, for issues of policy. What should be the policy of the government in drought relief? How should the government take care of migrants during pandemic? What should be the admissions policy of a college? How should political appointments be made? How should judicial appointments be made? What can you eat, drink, and smoke, and where? Right? Who can you marry? And what should be the relationship with your partner? How should the government run a business? And how should a government tax a business? There was a notice issued to the RBI by the CJI on repo rates. Even a core parliamentary function, which is to make the budget using money bills, is now subject to judicial review. So you can make someone, a student of law, maybe someone at the university, can make a very strong case that today courts are no longer just institutions to settle disputes, but they almost co-govern our country, something that, again, Sankalp sir alluded to, that everything is decided by the Supreme Court. There's a perception, especially amongst laypersons, that economic decision-making is in the hands of the executive and to some extent the legislature, while the judiciary only corrects mistakes by these two institutions. But the reality is that the judiciary is making policy choices on economic issues for the country. And while the courts have become more interventionist in the economic life of a country, whether they are more effective than the political process in making economic decisions is an open question, right? And the second sort of conclusion that I sort of draw upon from this discussion is that any time a court decides a policy issue, right, where two views are possible, judges, when they're deciding policy issues, judicial decisions almost always involve political judgments. And therefore, this perception that you often have as a law student that judicial decisions are morally superior to legislative decisions is not correct. In a democracy, judicial and legislative decisions have equal moral value. Right? What complicates the issue of judiciary being so deeply involved in the economic life of a country is that it itself is immune from the consequences of its decisions. A politician who makes a bad economic decision will lose the election. A bureaucrat will get transferred. A company will not make profit if it makes poor economic decisions. An individual will lose his or her job if they make bad economic decisions. What happens to a judge? And the other sort of issue which complicates the status quo is that unlike legislative and executive decisions, which are more easily reversible, they're more amenable to course correction, judicial decisions take sometimes decades to course correct once the reality of the country has changed. And the classic case is the 39B debate on this. There was this 1978 judgment in which Justice Krishna Iyer said that 39B of the Constitution, which talks about using the material resources of a community for common good, also includes private property. That there is no concept of private property under the Indian Constitution, that the government, in its wisdom, can take even private property of a citizen for common good. This was a view expressed by Justice Krishna in 1978. A debate which started in 1978 was only resolved in October of 2024, when finally a 9-judge bench of the Supreme Court, led by the Justice Chandrachud, said, no, private property is not an anathema to Indian socialism, that you can't give such a wide interpretation to common good that you begin to disrespect and disregard private property. A debate which should not have been had in a democracy at all, and yet it took so long to correct this view, this extreme view taken by Justice Krishna Iyer. Think about issues relating to arbitration. I can see Bishwajit sir sitting here. It should have been a non-issue that Part 1 of the Arbitration Act does not apply to international commercial arbitration. And yet, from 1996, when this new act came, it took till 2015 to finally clarify this non-issue, that actually, no, Part 1 should not apply to international commercial arbitration. You have the Bhatia International case, the Satyam versus Venture Global case, which took one extreme position. Another extreme position was taken by Balco. And then eventually a legislative amendment had to be made in 2015 to say that Part 1 doesn't apply, except if you want some interim relief from Indian courts. Think about the crisis that a mining sector faces today. Right? Our aspiration to be a developed country by 2047 cannot be possible till we don't have access to mineral resources, critical minerals. Right? Because we need to develop capabilities, world-beating capabilities in green technologies and frontier technologies. Neither of these aspirations will be possible if we don't have access to mineral resources. We have about 6 lakh square kilometers worth of what experts called obvious geological potential area, OGP, जहाँ पे की likelihood है mineral wealth. And given the similarities in our topography with that of Western Australia and Afghanistan, a lot of experts have said that there is an extraordinary amount of mineral wealth waiting to be explored in India. And yet only, I mean, Niti Aayog says 10%, Mines Ministry says 20%. A small fraction of this total area with obvious geological potential has been explored. And even a small fraction of that, less than 2%, has actually been mined. With the result that a country which is so rich in mineral resources is now, its import bill for bringing mineral resources is increasing over the last 5 years. We import about 60,000 crores worth of major minerals and about 30,000 crores, almost 1 lakh crore worth of minerals, which are critical to our energy security and our aspirations to be a developed country. There are lots of reasons why we have a dysfunctional mining sector, why we've not seen any foreign investment. Foreign investors have in fact sold off their assets under duress and left. Right. Even the blocks that have been allocated since 2015, we've allocated about 440 blocks of minerals since 2015, and greenfield mining has started, in my opinion, someone can check the data, in less than 20 blocks. So even the blocks that have been allocated, they're lying unused. There are lots of reasons for this dysfunction. Some of it is regulatory cholesterol. Some of this is, it's a heavily taxed sector. But you can't escape the fact that the Supreme Court view and a strong preference of the judiciary for allocation of natural resources is a big reason for this. Because no private investor will come and say that I will put in money to explore whether there is some mineral wealth here, and once I explore it, government will auction it to someone else. That no other mature mining jurisdiction in the world has this system of auctions. So let me just conclude by saying that what I said in my remark, which is that courts don't just perform a social and a moral function in society, they have a very important economic function to perform. And it is important, therefore, that when judges are deciding cases which have an economic implication, they must not just understand the legal truth of a case, but also the economic truth of a case. Please hire economic and sectoral experts as amicus curiae when you're deciding these cases. They will guide you on the economic costs and benefits of your decisions. By definition, the approach of courts when they're deciding cases is micro. It's focused on the specific dispute between two parties. But in a legal system based on precedents, their views then become the guiding principles, which may not be the economic truth of another case. Right? So you have to exercise judicial restraint when you venture into areas of economic policy making. So let me just end, because I've given 3 examples of courts not exercising judicial restraint, but I want to, you can sense that the culture of the Supreme Court is changing. They are beginning to realize their limited but important role in the economic life of a country. And so some of the recent decisions by the courts on arbitration, where they've pushed for a hands-off approach, is very encouraging. They've repeatedly chastised high courts for using rich jurisdiction to intervene in arbitration cases. These are great signs. And let me end with one of the most progressive judgments of the Supreme Court in 2017, which is the Shiv Shakti Sugars versus Sri Renuka Sugars case in which Supreme Court understood the interplay between law and economics to arrive at the right decision for a country. They said that in any policy issue, when we are deciding it, economic evidence plays a big role. And courts must always assess the economic impact and effect of a decision. And let me just quote 2 lines from this judgment and end my remarks, because I think they summarize everything that I've been wanting to say on this issue. It is time to consider the interdiscipline between law and economics as a profound movement on a sustainable basis. In other words, the economic analysis of a law is a valid jurisprudential approach to interpretation. You have to look at the economic value, the costs and benefits of a decision that you're taking. And finally, in the judgment, the court said, and I quote, "The court needs to avoid that particular outcome which has a potential to create an adverse effect on employment, growth of infrastructure, or economy, or the revenue of the state." This is a Supreme Court decision of 2017. These are the kind of progressive decisions we need to ensure that the next billion people of our country are lifted out of poverty and we become a developed country in 2047 when we celebrate 100 years of independence. Thank you.
Young friends, for your very emotional and articulated and well enriching discussions. And before I close this session, I think you are all happy because I'll be just making some closing remarks unless some of you want, because they are all so clear, you should not have any doubts. So morning, you see, Justice Vivek Agarwalji, I think has mentioned that we should divide, you see, all these 75 years into 3 phases. As per the contribution of the Supreme Court to Indian constitutional jurisprudence or constitutionalism. Perhaps you are not there in the morning. So, I think just while alluding to that one, the first stage is nothing but the Supreme Court said you. The second stage, the Supreme Court has said we. And third stage, it has said, see, I. It is like, Bhagavad Gita. You, I, and we. So the first 22 or 23 years, he said, legislature or parliament, you are supreme. Legisprudence. And second stage, here lies all your freedom, because what is the fundamental in the Constitution? Fundamental freedoms and dignity. And all those freedoms were buried. Parliament was aggressive. Supreme Court was silent. Allowed them to be buried. Yes, he said cemented. Then came the people's voice. This is what I call, see, how the people's voice has influenced the legislature. Because several people, you see, in fact, almost opposition was totally suppressed, and many people, you see, were jailed. It was known as Dark Ages. And from there, you see, the urge for freedom, that is almost, we can say, second independence struggle. But this is against ourselves only. And that was the movement ultimately forced the 44th Amendment to come, where they had by expansion Article 21, and the Supreme Court has expanded its jurisdiction. Till then, it has never touched Article 21, because it said Article 21, Article 19, Article 31, they are islands. We don't want to touch them. Only at that time, you see, Krishna here, you see, again, you see, he spoke the voice of the voiceless people. It is a continent and not an island. So from that, 44th Amendment has come and judiciary has become active. Till then, it was never active. Please recollect. Almost up to 67, it has not made any attempt to even say, legislature, you are not doing well. And This Shivkant Shukla is the best instance where you see it has simply agreed and has been a passive spectator. Then came suddenly Maneka Gandhi and all these things. Slowly they started opening Article 21 and everything they included in 21. And from there, you have got legislature, you have gone. Now it is for us. That started us up to 2000 almost. Here both asymmetrical fundamental rights also were upheld and economic development also was allowed and even federal-state relations also got settled because till then, federal, you don't find the term anywhere in the Constitution of India. You see the entire Constitution. It was more in the Government of India Act. And India has proclaimed itself as a union of states. But it has carved out federalism. And not merely carving out, it's a basic feature. And then she said that the states also have got independent identity, autonomy. Otherwise, well, friends, you are seeing how this thing, and this is manifest. Even the recent, see how the court has interfered with the governor's decision and says that it is deemed to have been accepted. See, this is how it has acted as a balancer, though we think that it has usurped the power. This is the struggle for what we call hegemony, constitutional hegemony, where you see it has first conceded to the parliament, then you see it has taken upon itself. Now it says, I am everything. As learned Hans said, I think, then Ivan Hughes said, what is constitution? Of course, that has reached almost no. Everywhere they started to see, whether you should have, why you are having mosquitoes in Air India, that also has become the contention. And whether you must have popcorn in a hall like this, cinema hall, that is also concern of Supreme Court. Everything has become. And ultimately, in same-sex marriages case, Suprio, where you see it was given by, you have to take care of the public ethos, public morality. What constitutional morality is not what you and I say, what the public says. Whether do they agree same-sex marriages? You might have made creative constitutionalism by agreeing there. Article 3, I think 73, 377, you have decriminalized. All right, but you can't validate the same-sex marriages here. And there is Justice Dhananjay Chandrood was in the minority. It is justice, but cautioned. We have our own limits. You have Raja Dharma, and you have also evolved Praja Dharma, and you have to respect constitutional maryada, constitutional courtesy. This is where the Supreme Court now has to now come down, and it has developed a constitutional culture where all the three can exist with respect for each other. This is what we call constitutional maryada. This is what you call constitutionalism. Respect for each other without encroaching into the others. So with these few remarks, well, friends, I think we close today's deliberations. I am very happy that all of you are present, and I thank all the panelists now for their very enlightening views. I am really enriched. Well, thanking you. Thanks once more. Thank you very much.
Thank you to our esteemed panel for that incredibly insightful discussion. The depth and breadth of perspectives shared have certainly given us much to consider on the Supreme Court's impact on our legal landscape and society. Sir, many in our audience are quite eager to ask questions following that stimulating discussion. With your kind permission, sir. Excellent, sir. We will now open the floor for questions. If you have a question, please raise your hand and wait for the microphone. Kindly state your name and try to keep your questions concise.
Thank you. My name is Arushi Rajagopala. I am a third-year student here at NLIU. I have a question for the panel at large. Firstly, thank you so much for the wonderful discourse. My question is to do on the running theme of the Supreme Court entering into the arena of lawmaking that all the distinguished speakers spoke about. But I wanted to ask specifically on two angles of it, which I believe may be the two extremes of it. The first being what Professor Lakshminath sir himself mentioned earlier, that is the case of Vishakha, where it can be argued, of course, that the Supreme Court made law, but some have also argued that it was required in that situation because there was no law existing at the time. And the other extreme might be, for example, last year in the month of October, there was an interpretation that was done of the GST laws, which in this year's finance bill completely overruled that judicial decision. So my question essentially is, there appears to be a tussle between the legislature and the judiciary on this particular aspect, and I wanted to know the opinion of the panel as to what should happen going forward.
I think there are two things in this. Supreme Court functions on two things. One is legitimacy and second is certainty. Legitimacy is something where you would understand that we the people, who goes to the court? We the people, right? Everything which is there, which is taken to the court, is not that the Supreme Court has done it. People are going to the court. So that gives legitimacy to the Supreme Court for everything we are now asking the Supreme Court to actually legislate upon. That's what the Supreme Court is asked to do. So that's what legitimacy of the courts are. So that gives an answer to everything which is going to the court. We the people are taking it. Who are the litigants? All private litigants, right? The second is about certainty. I completely agree with you on that particular point. Let's take example of the Vodafone judgment, which actually did the rounds of around 3 rounds where Vodafone eventually got an order, but it could not be implemented as well. So that was a big dent, what my learned friend was talking about, the certainty in economic issues. So that was a bad blot on the Supreme Court, the Vodafone judgment, where eventually, despite the fact that Vodafone won from the Supreme Court, was not able to realize the economic benefits of that judgment. And eventually, it was a validation act which was brought in, and eventually it was nullified. So these are the two tussles which keep happening in the Supreme Court, but we have to understand one thing, that Supreme Court actually has the biggest legitimacy which any court in the world does not have. Everything which is going to the court is because of what we do. Try and understand that no matter what happens, no matter what we legislate upon, be it 370, be it the Ram Mandir case, everything gets a quietus to the issue when the Supreme Court decides it. Rightly or wrongly, that's a separate issue altogether. That's the legitimacy which we the people are giving to the Supreme Court. So I think that's where it is coming back to. It is not, and I completely agree with sir, Supreme Court today is not overtly active. It now, and I completely agree with my learned friend as well on that, where Apur says that now Supreme Court is actually receding itself from being overtly active about things which is not expert to. And examples are obviously those economic issues. Examples are these judgments where the Supreme Court said that we're not going to legislate on moral issues in the same-sex marriage cases. So I think it's a balance which we need to strike, but till the time the executive and the legislature is not performing its functions, unfortunately or fortunately, the Supreme Court is forced to do it. Try and understand that we are taking all these issues to the Supreme Court. The Supreme Court is not asking. The activist days in the 1970s, where the Supreme Court on letter petitions was suo motu taking up PILs, was a different era altogether. That's not happening today. Today, everything which is happening, and the admission rate, and Saurabh sir would be the perfect person to actually endorse that view. The rate of admission in the Supreme Court is minuscule. Every day, everything is coming to the Supreme Court, even designation of, senior lawyers, appointment of judges, everything. The executive, legislature, every issue, small circulars to memorandums, everything is being challenged. And that's not in the Supreme Court. The high courts are getting everything, right from where the urinal should be, where public toilet should be, everything is going to the Supreme Court. From the high courts and traveling, everything is now traveling to the Supreme Court. So who's taking this? It's the legitimacy of the Supreme Court, where we think it's the Supreme Court who will decide every issue. So therefore, I think that's the legitimacy which Supreme Court enjoys, and that's what makes the Supreme Court of India that powerful.
Thank you, sir.
Can I just add to what you said? If I've understood your question correctly, what you were saying is, we have cases where the Supreme Court has legislated and it has helped. And there are also cases where it has crossed the boundary. So where do we draw the line? So what was done in Vishakha was, there was no legislation regulating sexual harassment at workplace. So the Supreme Court, because it's vested with the power under Article 142 to do complete justice, laid down guidelines to be followed for this particular problem. And they were to remain in force till a particular legislation was passed by the parliament or the competent legislature. So that is where the power is, you are right, correctly exercised. There are also where the Supreme Court enforces legislations, where laws are made by the parliament or state legislatures, but they are not followed, not enforced. And their public interest litigations are filed and directions are issued, and all that the court is saying is to follow the law. But the trend that we are seeing is, and on which the other panelists have spoken extensively, is the interference by the Supreme Court on policy matters, economic policy, social issues. Just what Professor was referring to about issuing a mandamus to recognize same-sex marriage. Can a subject matter of that kind be entertained by the Supreme Court in exercise of its power of judicial review? That is where it crosses the boundary. So that is where the balance is to be maintained. The balance is, you can exercise PIL power to enforce laws, but you cannot sit in appeal on the decisions of the government on social matters, on economic matters. The decisions taken by the government is by the government because they have a mandate from the people. If the decisions are wrong, it is for the people to take a call, not for the court.
Thank you, sir.
Okay, thank you all. Any more questions?
Yes, sir, I have a question. Good evening, everyone. I'm Tanishka Tomar, a fourth-year student. And my question is specifically to Apurv, sir, and it could also be an extension to the last question. So, sir, you have mentioned that Supreme Court is not just now a rectifier, it's also someone who's taking a lot of decisions when it comes to the economic landscape. So, when we talk about monetary policy, fiscal policy, there is a very clear-cut distinction between RBI and our Finance Commission. However, when we talk about Supreme Court interfering there or taking decisions, do we have people competent enough sitting in the apex court or even the high courts? And also, my very specific question, because law and economics, the interconnection between these two subjects has recently come. I can say a decade or a couple of decades at max if I would go. So do we have people competent enough sitting here who are 50 years, 60 years that they can actually interfere in the arena of RBI or the Finance Commission?
No, but I don't think this link between law and economics is new. I mean, look at most of contract law. Contract law has codified essentially what was business practice for centuries. So there's a very ancient connection between law and economics. We are rediscovering it again through jurists like Posner, etc. in the United States. And typically, US jurists have played a big role in rediscovering this link between law and economics. But let me make first a general point, and it sort of answers both your questions. And this is something I learned from Professor Ander Bete. He always used to say that in any democracy, for any democracy to function, there must be an equilibrium between two equally important but opposing principles. Rule of numbers, as represented in elected institutions, parliament, state legislature, etc., and rule of law, as embodied in unelected institutions like Supreme Court, Election Commission, UPSC, which don't have to subject themselves to public pressure. And it is the tension between rule of numbers and rule of law which creates the equilibrium for a healthy democracy. So that's a larger point. So you must not say that, okay, one set of institutions are more important than the other. You must always seek balance between these two principles which create a healthy democracy. But if you ask me my personal view, I think courts should be a little more proactive. The posture should be more forward-looking on issues of political and civil rights. But on economic issues, I think they should be a little more hands-off. Right. And I was just, when you were asking that question, I was looking for this quote which I used in one of my internal notes. there's a 2021 speech, November 2021 speech by Lord Legat of the UK Supreme Court, where he gave a beautiful speech on what is a point of commercial law. That was the title of the speech. And he said that the point of commercial law is to facilitate commerce, because commerce is a moral activity. It is not a bad thing. And therefore, the purpose of the court should be to promote commerce through their interpretation of commercial law. And there's I think, a beautiful quote in his speech, which I'd like to share with you, which says, and he talks about the role of the judiciary. He says, "We are there to help the businessman, not to hinder them. We are there to give effect to their transaction, not to frustrate them. We are there to oil the wheels of commerce, not to put a spanner in the works or even grit in the oil." This is the hands-off approach I'm talking about on economic, commercial issues. On political and civil issues, I think it's great. And on that, I think, as the other three speakers have said, our Supreme Court has an extraordinary track record. I mean, we are today a functional democracy largely through the courage of the Supreme Court and its judges through all of those decades when there were such severe pressures. So those are my 2 cents on the issue.
Now, to formally conclude today's proceedings and share his reflections, I have the honor of inviting our esteemed registrar, Mr. Vivek Bakshi sir, to deliver the concluding remarks for day 1.
Esteemed guests, faculty members, and dear students, as we come to conclusion of the day 1 of this wonderful law conclave, on behalf of NLIU family, I have the privilege to extend our thanks to all the guests who have traveled from different places despite their busy schedules. Also, the inaugural was graced by the presence of Honorable Justice Pankaj Mittal ji, Supreme Court Judge, also our visitor, the Honorable Justice Suresh Kumar Kaid ji, who is also our Chancellor, and Justice Vivek Agarwal ji from the MP High Court. We also extend our thanks to Honorable Justice Retired Shri K.G. Shankar ji, who chaired the first panel discussion on the Supreme Court and the basic structure. We are also deeply thankful to Honorable Justice Retired R.M. Borde ji, who chaired the second panel discussion. Our gratitude to Professor A. Lakshminath ji, who chaired today's postcard session. His contribution brought academic rigor and perspective to the table, greatly benefiting our young legal minds. A special note of appreciation to our Vice Chancellor, Professor Dr. S. Surya Prakash ji, for his continued support and leadership in making this conclave possible. I also wish to acknowledge the relentless efforts of the Student Bar Association, whose vision, hard work, and coordination have brought this event to the life. Also, we would like to thank our distinguished speakers, who are also our past students. It's always a pleasure to have you on the campus.
and it is very heartening to see you're doing so well in your life, and wish you all the success. Mr. Vishwajit is here, Mr. Saurav, Mr. Purva, and Mr. Sankalp Kochar. And we also see Siddharth Gupta ji, he will be also here. And tomorrow we are going to have another sessions, and we wish that this will be as useful as these today's sessions were there. And I'm hoping that we will have more students. This is a lifetime opportunity for you to learn from the legal luminaries who are doing so well in their fields. And like Professor Lakshminath-ji, who has so many years of experience, when he speaks, you are mesmerized by his wisdom, his depth of knowledge on any topic. I think we also should acknowledge the hard work done by our SBA President, Yashpal Jhakar, Priyanshu Gupta, and all the SBA team members who have done wonderful job. A big round of applause for them. Finally, I thank all the faculty members, staff, and participants for their contribution to today's success. We look forward to another day of meaningful discussions as we continue to celebrate 75 years of the Supreme Court of India. Thank you all.
This young boy has worried.